Assignment. I beg to mention item number 19 and 20, my lord.
20.
My lord, this case, my lord, earlier deal by learned counsel N. Ratan, my lord. Now his appointment is a additional AG, my lord. I have a instruction, my lord. Clear instruction to appear in this case, my lord.
Okay.
But I am yet to, my lord, file my authority, my lord.
On behalf of the appellant.
Appellant, my lord. May I pray, my lord, this will be listed after 3 weeks, my lord. I have informed the other side, my lord.
Okay. Yes. I'm proceeding. Mr. L. Parme, learned counsel submits that he has recently been engaged to appear on behalf of the appellant
My lord.
and prays for some time. Mr. Tado, learned PP, has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
High level, sir.
My lord, I beg to mention item number 1, my lord, on behalf of E. Parme.
Okay. So what do you want?
After 3 weeks, my lord.
You are Mr.
The other. I on behalf of E. Parme.
Okay. Who is for the other side?
Yes, my lord.
Who is for the other side?
The other side is I informed the other side also.
Have you informed?
Yes.
Yes,
I informed.
You are seeking adjournment?
Yes, my lord.
You have any objection?
No, man.
Okay. Mr.
The other, my lord.
Appearing on behalf of
E. Parme.
Ms. T. Parme, learned counsel for the petitioner, prays for
3 weeks, my lord.
adjournment of the case
Oh,
for 3
sure.
weeks, to which Mr.
M. Doziman.
learned counsel for the respondent has no objection. Accordingly, the prayer is allowed. List is met after 3 weeks. Okay.
Obliged.
My item number 2, my lord.
Item
Number 2, my lord.
2,
Yes, ma'am.
same,
Yes, ma'am.
same prayer.
I'm the respondent in item number 2, madam.
You are for respondent,
Yes, ma'am.
and who is for the
Other side
petitioner?
is for B Tapos. I have taken the consent from the other side also, ma'am.
Mr.
The other man.
learned counsel for the respondent on the consent of the learned counsel for the petitioner prays for listing this matter
After 2 weeks, ma'am.
after 3 weeks. The prayer is allowed. List this matter after 3 weeks.
Much
Okay.
obliged.
My lord, I beg to mention item number 20 and 22. I am appearing on behalf of father 20 and 22.
Make appeal.
Yes, yes, my lord.
So why?
My lord, senior counsel is out of session due to some urgency.
Road of disposal. Okay. You are Mr.
D. Fango. D. Fango.
What about the other side?
Pardon, my lord.
What about the other side? Opposite
uh,
party?
Consent has been taken, my lord.
Consent.
Yes,
You are Mr.
D. Fango.
Appearing on behalf of Mr. U. Deka, learned counsel for the appellant on the consent of the other side. Prays for
My lord,
listing this matter
may I
after
pray that maybe after 4 weeks.
4 weeks.
Yes, my lord.
The prayer is allowed. List this matter after 4 weeks. Okay. Okay.
Obliged.
Lordship, I beg to mention item number 23.
20?
23.
Okay.
I'm for the petitioner. The leading counsel is out of station. So this matter may be listed after 3 weeks.
You are for appellant?
Gimi Tarak, petitioner,
Okay,
yes.
appellant. And what about the other side?
I have obtained,
Final appeal.
I have obtained concern
Okay.
from the opposite party.
Okay. Okay.
It may be listed after 3 weeks.
3 weeks.
Yes.
Okay. You are Miss
Emiaram.
Amiram, appearing on behalf of Mr. Gimi Tarak, learned counsel for the appellant. Prays for and submits that the leading counsel is out of station and hence I pray for adjournment. Miss Agay, Learned Counsel for the respondent has no objection. Accordingly, the prayer is allowed. List this matter after
3 weeks.
3 weeks. Okay.
I for respondent number one, Lordship. For
Respondent number
state,
one.
yes, Lordship.
Okay, respondent number 1. Okay,
Deeply obliged.
Obliged.
With the consent of other but opposite counsel, I beg to mention item number 4. The matter has been, this is the bail hearing fixed for today. But the council's, senior counsel is from Delhi. Due to his personal inconvenience, he is not able to present today. Therefore, matter may be examined after Bihu vacation.
okay. Mr.
M. Kamcham.
M.
Kamcham.
Learned Counsel for the petitioner prays for listing this matter after
After
Bihu vacation.
22, 23, any date may be given.
After 3 weeks. After 3 weeks, that will do. The prayer is allowed.
In the
You
min,
want the case to be fixed?
fix on 22 or 23, any date can.
Pray for listing this matter on 23.
In the meantime, interim may be
Prayer is allowed.
continued.
List this matter on 23. Stop. The interim order passed earlier shall continue till then, till the next date. Okay.
Obliged.
My lord, I beg to mention item number 12. We supposed to file IA on this matter.
Item
12.
12.
12.
12.
Yes.
Ah.
We supposed to file IA on this matter to implement the party, the complainant. But difficulty is that the petitioner is from Guwahati, so he has not reached today. So I may beg to allow for 1 week time to file the IA.
Petitioner has to file what?
IA,
IA.
yes.
IA for what?
Implement of parties. Party respondent number to the complainant.
Okay, let the matter be called for. We'll pass order.
Yeah.
You have not yet filed any IA
No.
impleading the party. Okay, let the matter be called for.
Yeah.
You are leaving the court.
Yes.
Hmm?
Yes, you know.
Okay, you are Mr.
Tipahi.
Hmm?
Tipahi.
Your name is there.
Yes.
Okay. Praise for and is granted 3 weeks time to file IA impleading what? Respondent.
Yes.
File an implement petition. The prayer is allowed. Oh, sorry. Granted, huh? Okay. List this matter
1 week.
after
1 week.
1 week. Then make it 1 week. Huh? After a week. Okay.
And for the
Miss-
state, Lordship.
Miss Hage, L. Hage, appear on
For state, one, Lordship, one.
for the respondent state. Huh? Okay. Yes.
Obliged.
May I please, Lordship? I'd
Yes.
like to mention item number 5 and 6, Lordship, on behalf of J. Sring, Special PP SIT. Lordship, we are yet to receive CD on this matter. Kindly, it may be taken up after.
This will be called just now only. I think it will be called now. Wait for.
Yes, Lordship.
It will be called. Because other matter already adjourned.
Yes.
Be there for some time. Okay.
Okay. Obliged.
My lord, I'd like to mention item number 18 on behalf of Mr. Deep Oje. He is a leading counsel. Now he is out of station for urgent ground. The matter may be refixed after 3 weeks with the consent of other party.
You are Mr.
Mr. Teli Ango.
for the appellant.
Yes,
Tiango, your name is not there.
sorry.
Your name is there in the cause list.
Yes, yes,
Okay. Tiango, Learned Counsel for the, you are for the appellant only?
yes, appellant,
Appellant or respondent?
appellant.
Ango is, okay, Learned Counsel for the appellant, praise for. What about the other side? Have you informed?
Yes, with consent of other party.
Okay, Mr. Ango, on the consent of the other side, praise for listing this matter after
After 3 weeks.
3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Thank you.
Lordship, I beg to mention item number 16.
16.
Lordship was the PO in criminal
Okay,
petition.
okay. The judgment was passed by me.
Yes.
Okay. So,
Matter may be fixed in any other.
okay, list this matter before the appropriate court without me. Okay. Okay.
Much of.
Lord, I'm on behalf of the petitioner, my lord. So yesterday we were telephonically informed that the council will not be appearing today. So they will be taking some more time, my lord.
You are for the
Petitioner, my lord.
petitioner, and who will not be available? The other side.
Yes, ma'am.
Okay.
No, no, no.
So you are praying for. the
Yes, sir.
adjournment.
Yes, yes, my lord.
Okay.
Any other date may be given, ma'am, after Bihu.
You are Mr.
B. Niarus.
Land Council for the petitioner. Heard Mr. So and so, Land Council for the petitioner. Stop. Also heard Mr. PP.
Theater, your lordship.
Theater. You are
for the respondent too.
theater for
Lordship,
matter additional PP, huh? And Mr.
Arkuyu.
Correspondent number 2, stop. No one appears on behalf of.
Your lordship, actually, this case has been looked after by the public prosecutor himself. So
Okay.
today he is absent, and for that reason, your lordship, we are seeking time, your lordship.
Okay. Is, no one appears on behalf of the respondent.
The respondent is appearing, your lordship, only from the prosecution side, your
Sorry,
lordship.
prosecution side.
Yes, your lordship. Public prosecutor has taken, is looking after this matter, your lordship.
Okay, as prayed for by the Land Council for the parties, list this matter after
3 weeks.
after 3 weeks. Okay.
Deeply obliged, your lordship.
Yes, you have mentioned.
Yes, we are yet to receive CD. I'm appearing on behalf of Special PP SIT.
Okay, okay.
We are yet to
CD
receive
yet to be
CD.
received. Yes, okay.
Kindly, it may be taken up after Bihu break.
After?
Bihu break.
My lord, can it be fixed on 6th of May, my lord?
Okay. Or Mr. While you are for petitioner,
Yes, ma'am.
Mr.
B. Niarus.
Land Council for the petitioner. And you are Mr.
T. Gatsu, on behalf of Special PP.
On behalf of the Special PP, SIT. The CD, the case sir, is called for. It's still awaited. Is prayed for by the Land Council for the party. List this matter after.
My lord, on 6th of May. Yes.
List this matter on 6th May. Okay.
Lordship,
Both the item? Yes, yes.
in the matter, I am appearing in person. I am the informant on the basis of which complaint
which item?
this
Which
FIR
item?
has been lodged by the SIT. And I seek the leave of the court to file an affidavit in opposition to this petition of anticipatory bail being heard. I seek the leave of the court to be granted such a permission.
Okay. Just a minute. You are for?
I am Manish Kumar Agarwal, the informant who has filed a complaint with the Doimuk PS on 22nd of April 2023, sir.
Okay. You want to file objection?
I seek the leave of the court to file an affidavit in opposition against the petition seeking anticipatory bail for the petitioners in item number 5 and 6 both.
Mr. Manish.
Yes,
Mr.
sir.
Manish, appearing on behalf of the informant, praise for allowing him to file, seek leave of this court to file objection. The prayer is allowed. Okay. It was fixed on, it is fixed on 6th May, 6th of May. In the
6th of
you
May.
can file. Yes.
Lordship, if I am so allowed, can I make a humble submission before the Honorable Court?
Yes, what is that?
When the matter is heard again on 6th of May, let the state through SIT be asked to file an affidavit stating that whether they have recovered the excavator 676 in the case.
No,
Because
we've called for series. CD, it will be in the CD.
okay, fine. I'm obliged. I'm obliged. Thank you, sir. Thank you.
5 and 6. 6th May.
Deeply obliged.
Obliged.
May I plead your lordship? Possibly the fourth time application.
Affair is at page 11. Page 11.
Affair is at page
11, madam.
Yes.
May I read?
Yes, please.
It is to inform you that today on 18/2/2024 at around 16:12 hours, information was received from so-and-so of so-and-so police gate over phones of that Xylo vehicle number so-and-so, Bolero vehicle number so-and-so are suspected to be carrying suspended contraband of cannabis from Kalaktan and going towards Bhalapur without making entry at check gate, taking advantage of the opening the check gate to other vehicles. Accordingly, he has followed the vehicle after intimating the OCPS Bhalapur as there is information that both the vehicles is carrying suspected contraband of cannabis before 2 weeks. Accordingly, self along with the HC so-and-so left from Kamala to breathe after informing executive magistrate Bhalapur and independent witnesses. On arrival at Kamala, 2 special Naka was conducted with the executive magistrate Bhalapur and independent witnesses. During Naka and Bolero vehicle number so-and-so was seen coming towards Bhalapur, driven by Sri Devang Mudoy, aged about so-and-so. With 2 occupants, Angsuma Doimari. I am for this one, madam. Angsuma Doimari, aged about so-and-so. And another one, Sri Nizam Doimari, my lord. Accordingly, search was conducted after issuing notice under section 50, but nothing could be found. The accused was in Bolero, my lord. Nothing could be found. Therefore, the vehicle and the occupants were allowed to go. After short while the Xylo vehicle number so-and-so was seen coming towards Bhalapur, driven by Gautam Mora, aged about so-and-so, and these are the occupants. Next page, my lord. Aged about 26 and so-and-so conducted after issuing notice under section 50 NDPS in presence of executive magistrate Bhalapur with 2 independent witnesses. During such 45 number of polythene bags containing so-and-so contaminants suspected by cannabis weighted and recovered from the Xylo vehicle, my lord. So the case is this, my lord. 2 vehicles were there. I'm in a vehicle in Bolero, my lord. Nothing was recovered from my vehicle, my lord. But the occupants of the Xylo said that okay, he was also involved along with us, my lord. So I was also arrested, my lord. The case is this, my lord. Thereafter, I was taken to the custody, my lord. But my case is there. I filed this bail application on medical ground, my lord. The condition of the accused is that both the kidneys are on failure, my lord, and he is continuously going on dialysis, my lord. On the last occasion, Your Honor, this Honor was pleased to call for the case diary along with the medical report. Whether the medical report is within the possibility, I don't know. The medical report is necessary, my lord. I have also collected one medical report, my lord, which was Your Lordship was asked from the jailer, my lord. The condition is this, my lord, that the accused, both the kidneys of the accused is failure, my lord, and he cannot survive over in the jail, my lord. So he has to go a transplantation of the kidney. His father is ready to donate 1 kidney, my lord. That is the case. I'm not going into the merit of the case as now, my lord, because As your lordship knows, section 37 bars the release of an accused under the commercial quantity of cannabis, my lord, that is there. But I am only on the ground, on the medical ground, my lord. Whether the CD has come or the.
Yes, CD receipt, but there is no any medical documents.
My lord, I have collected the medical documents, my lord, lordship, lordship, kindly produce. May I read, my lord?
Just a minute. So, he is in jail now.
Jail, my lord.
So this medical is of which date? Medical document is of which date?
My lord.
Medical document
Medical document, my lord.
is of which date? While in the jail?
Jail, yes. While in jail, my lord.
Okay, how did he get it?
I asked for from the jailer itself, my lord. Jailer himself told me that the physical condition of the accused is very bad, my lord. He will not survive for many days, my lord. That is the condition.
Yes.
He also mailed it. May I read it, my lord?
Which one?
This I'm going to first of all may I allow to read, my lord?
Yes, please.
To the deputy registrar and so on subject. Inviting to the letter reference above received on 21 to 2024, it is to inform you that petitioner Ansuma Devmari was locked at UTP cell Bomdila on 23 to 2024, white case number so and so, Bhalapur. As per the perform of health screening of the petitioner's copy, annex and annexure done before lodging into the UTP cell, it is said that the petitioner was suffering from kidney failure and was under dialysis. On 22/8/2024, the EMO of the General Hospital Bomdila referred the above petitioner to dialysis center Dirang for further management, and 29/2/2024, the petitioner underwent dialysis copy so and so. While medical examination report 9/2024 so and so by medical officer, community health officer Dirang, so and so, the petitioner is suffering from chronic kidney disease, which needs weekly maintenance of hemodialysis, my lord. So this is an admitted fact, my lord, that the petitioner is, the condition of the petitioner is very worse, my lord. Both the kidneys failure, my lord. And there is no other alternative way to survive, my lord. Transplantation of the kidney, my lord.
Who is sponsoring the expenditure for?
Government is
government?
government, my lord. But there is in Bomdila, there is no such facility, my lord, to help with patient dialysis pattern. Their medical is not so advanced, my lord. That is the main problem. At least dialysis has to be done in weekly twice a week, my lord. But they are doing once a week, my lord. That is the main. First of all, that is another problem. Your lordship, may kindly peruse page 7 now, my lord. This is the reference to dialysis. Every week they are doing dialysis on 20 to 2024, 29 to 2024, my lord. Then next page on the page 8, my lord. Page 9, my lord. Known case of chronic kidney disease and need dialysis, my lord. The medical officer is itself very clear, my lord. And my lord, my kindly peruse in the pages.
Page 7, what?
My lord.
What is there in page 7?
Page 7, my lord, on 28/2024, Ansuma Devmari disease referred to dialysis on 28/2. Again on 29/2/2024, Ansuma Devmari maintains dialysis measuring so and so. 9 on 9th, then again next date is 9/20. This is a chronological order. Dialysis is going on, my lord. Once in a week, my lord. As your lordship knows, my lord, a dialysis patient cannot drink much water, my lord. In an hour, he can drink at best 2 spoons of water, my lord. That is another thing. He cannot eat food, my lord, like this on what is given in the jail, my lord. That is another problem. The medicines are not there, my lord. He needs immediate surgery, my lord. The transplantation of the kidney, my lord. And his father is ready to donate 1 kidney, my lord. My lord, you can peruse page 21 of the petition, my lord, for a moment.
What is that?
Page 21, my lord, of the petition.
What is that?
And
What
the
is
three,
that page 21?
my lord. That is the medical report, my lord.
This
Down,
is
down bottom, my lord, para 3, my lord,
earlier report.
21, my lord. Annex to 3, my lord, page 21.
So this is also while he was still,
Yes, in the very
Well-
bottom, may I read, my lord?
yes.
Male is hypertension patient with BP 200 to 150, my lord. The BP is very high also, my lord. There is a very conditional stroke, my lord. Undergoing dialysis treatment. And this is the referral from the doctor. He is not fit to be kept in lockup, my lord. This is the statement of the doctor, my lord. He is not to be kept in the lockup.
Doctor of which medical?
That is that one, my lord. Medical college. This is.
Forwarding here also.
Malapur medical page 23, my lord, can you kindly finish? This is the medical. Malapur, my lord. The day one who has arrested, my lord. Page 23, the seal is there, my lord. At the right side, my lord.
Page 22.
23, my lord.
Okay, what is there?
The seal is there, the doctor's seal is, my lord, there in the medical corner. CHC Bhalapur, my lord. And date is there, 18 to 2024.
Not clear. Okay.
So doctors are also very specific, my lord. He is not a kind of a patient to be kept in the lockup, my lord.
Just a minute, sir. Okay, where did we- After a week. Six. Here regarding his latest health condition was called for. So yes, RPP, any record, CD has come. CD come, but there is no medical document. Medical document, but the medical document was also called for. Only in petition. Medical documents are annexed only in petition. Okay.
Medical documents were
But then the record was called for, is
already I have.
jail authority, from the jail authority, where the petitioner is now detained, shall forward a report regarding his health condition.
My lord, I have just produced, this is the document, my lord, whatever the jail authority sent it to the High Court, my lord, this is the copy, my lord, exact copy, this is what I have given you, lordship. So what
Copy from where?
From the jail authorities, my lord. This is to the deputy registrar of Guwahati High Court.
Jail authorities should send copy.
They have also said had mail also, my lord. They said that since it's coming from Bombay, it is not possible to reach within a given period of time, my lord. This is very difficult.
CD is from IO.
CD is from the IO, that is there. There is Bhalapur.
We have not sought any documents from jail authority. Okay.
So nothing was, that medical document was got from the jailer itself, my lord. That was I have produced before your lordship. It is written to the deputy registrar of the Guwahati High Court, my lord.
Ask the jail authority to send a scan copy from mail.
They have
Tomorrow,
already sent a scan copy to the mail also, Guwahati High Court mail also, my
Mail?
lord. Mail, my lord.
When?
On that day, 21 March, my lord. 22nd March, my lord. The exact copy of what I have given to your lordship.
What is there in CD?
CD, there is a direct involvement of the accused.
Okay.
210 kg of cannabis.
210 kg.
He is a middleman who used to pay money for procurement and transportation. From Arunachal to Kalakar to Tinsukia, Assam.
Okay.
And that 210 is commercial quantity.
Yes, sir. So now he is not on merit of the case. So ensure that the medical document comes from the jail authority. And if there is any record from this High Court also, if they have sent through mail.
My lord, if you will also can take this matter after some time, I can inform the jailer of the jail. He told me he can give me the exact time, my lord. It is in the mail of the Guwahati High Court, my lord. The same can be connected today itself, my lord.
Sent by the jailer?
Be sent by the jailer, my lord. I have, whatever I have produced before your lordship, this one, my lord,
Maybe, but then because you say,
Absolutely, that is there.
you're not praying for,
My lord.
praying on merit.
My lord, I'm not praying on merit, my lord.
We need to ensure that the
Sure,
document comes
absolutely,
from the
absolutely, my
conflict authority.
But looking into the health condition of the petitioner, it is very,
Yeah.
you will not survive for so long, my lord.
That is why we call for
My lord.
the document
My
from
lord,
the
can
jail
matter be
authority.
taken after some time, my lord? In between, I will select the, I will inform the registry over here to produce the copy from the mail, my lord. It is in the mail, my lord. Think into the nature of the case, my lord. If whatever I have, whatever the documents produced by the jailer, if it is true, my lord, then the condition is very serious.
How long he had been there in the jail?
More than 1 month, my lord. The doctor has given in time of 3 months to operate, my lord, kidney. Both the kidneys are failed, my lord. Or 2 months is there, my lord. He will not survive, and the medicine is not there, the food is not there. And the BP is 200 by 150, my lord. That is another issue, my lord. Stroke can happen.
Arrested on 18th February.
18th?
Arrested on 18th February.
18th February. So, telephonically also,
My lord, if
you can obtain instruction this afternoon. Can we take up this afternoon?
From jail authority.
I have the
Jail.
number of the jail authority, my
Hmm?
lord. I have the number of the jail authority, the jailer. I can give to the London PP, my lord. He can directly talk with the people, jailer.
Nowadays is EG, mail or.
If there is any mail in our High Court website,
Okay.
then we can collect it from registry.
Okay. Let it place tomorrow.
My lord, I have a very, I have some family problem, my lord. I have to leave for Guwahati, my lord. Can be today at late afternoon, my lord. Sometime after sometime. Because mail can be collected within 10, 20 minutes.
Try to find out. No? If they have sent to the High Court.
And my lord, I am also giving him the number of the jailer also. You can telephone.
Ask him to send, mail the document. What they have sent through the post can be sent through mail. Yeah? Okay. So we'll take up in the afternoon.
Fine.
Okay.
Take up.
Pass it for the
Yes,
time.
definitely.
This was 26. 26. Okay, 7.
Yes, ma'am. My lord, service report is still available.
Yes, sir.
Service report is still available.
One and two.
No, one to 4 months. Four months.
1 to
4.
4.
Yeah.
I think you need to take fresh steps.
Yes, my lord. My lord, I have one prayer, my lord. Allow me to take my lord justice service upon respondent number 3, my lord.
3 by Dusty.
Yes, ma'am.
And about 1 and 2?
Other
1, 2 and 4?
And respondent number 1 and 4 through OC, consent OC. Yes.
Okay.
And my
Hard,
lord,
hard, Mr.
respondent number 2 through consent commander.
Hard, Mr.
DR.
E.
ER.
Ado. And counsel for the petitioner. So, no one appears on behalf of the respondent. So, the office note dated 13/4. No, 4/1/24 and 1/4/24 reflects that the notice upon the respondent number 1, 2. Where is about the 3?
Respondent number 1 through respondent number 3, my lord, justice service.
Okay, 1, 2. And service will start with the in service of the mail to receive in respect of respondent number 1 and 2. Where is about the 3? 3 also not found.
Yes, ma'am.
The person not on the address not found. Okay. The service upon the respondent number 1, 2, 3, where 3 and 4 are 3 and 4 return with the postal note that's not known, address not found, address not found, and in respect of the service upon the respondent number 1 and 2 is still a week. In view of the above, the land council for the petitioner prays for allowing him to take fresh steps upon the respondent number 1 and 2 by and
1 and 4 by concerned OC.
1 and 4
Yes,
by
1 and 4.
concern OC
Yes, madam.
and
Respondent number
2 and 3
to concerned commandant.
commandant.
Yes, madam.
All of them are police.
No. They are
Commandant.
Commandant, he husband of the respondent number 3. Madam. Respondent number 2 is the husband
What?
of respondent number 3. He is posted in Jammu and Kashmir.
Okay, they are police.
Yes, ma'am.
Okay. Respondent number 2 and that was 1 and 4. No?
Yes, 1 and 4 to
Pro
OCPS.
OCPS and
Yes.
2 and 3 pro
No, respondent number 2 to concerned commandant.
2 through concern commandant and 3
3 to justice service.
and respondent number 3 by dusty service. The prayer is allowed.
And my lord, there is an interim order that may be complete.
Just a minute, huh? The petitioner shall take steps within a week from today. Okay, stop. In the meantime, the what interim order? This is
Interim order.
okay. The interim order passed earlier shall continue till the next stage. Okay, list just before that list is matter after 4 weeks.
Okay.
Okay, the interim order passed earlier shall continue till the next stage. Okay,
Much okay.
yes.
Lordship, we have received the service. I'm for the respondent. Kindly it may be fixed after 3 weeks. In the meantime, we will file our wakalatnama as well.
Okay. Miss
Yelasha.
Land Council for the appellant. Mr.
T. Gapson,
Would appear on behalf of
all the respondent.
all the respondents and prays for some time to file wakalatnama. The prayer is allowed. List is matter after
3 weeks.
3 weeks. Okay.
Obliged.
Though the matter has been listed for orders, Your Lordship, this matter can be disposed of.
Hmm?
Though the matter has been listed in orders column, Your Lordship, this matter can be disposed of, Your Lordship.
Dispose?
It can be disposed of, Your Lordship.
Okay.
It can be taken up for disposal.
What is this matter about?
My lord, what has happened in this is that a dispute regarding a land has arose between the petitioner and the respondent, Your Lordship. And pursuant to
Who is for? Just
My
a minute,
lord.
just a minute. You're for
for the petitioner.
petitioner and you're for?
But respondent, madam.
How many respondents are there?
Sole respondent,
Sole
madam.
respondent.
Sole respondent.
My lord, this may be, this can be disposed of, my lord. I agree with their submission, my lord.
Okay.
Only, my
Disposal
lord,
by
only, my lord, that the grievances of the respondent, my lord, since it's matter pending before the appellate court, my lord, it can liberty may be granted the petitioner to raise his grievances before the appellate court, my lord.
The only during the pendency of the appeal, madam, this, the summon has been issued, madam. Press complaint has been lodged, madam. That's why, madam. It's the case.
The appeal is
Pending
pending
for-
against the impugned order.
Yes,
Appeal
ma'am.
pending before which court?
Civil judge, senior division, Pasigat. Civil judge, senior division, your lordship.
Civil judge,
Yes, your lord, Pasigat,
Pasigat.
senior division.
And initially, during the pendency, madam.
During the pendency,
Yes, basically, madam, there was the complaint before the Blaze Authority. Blaze Authority, by Keba, by the judge passed the order, madam. The impugned decision of the Keba was challenged before the appellate court, that is pending before the civil judge senior division. So during the pendency, madam, some of the issue, madam, saying that this issue was not specifically mentioned in the earlier complaint, although it is covered up, madam. The press complaint was lodged before the
Same-
Keba,
Same
same Keba.
village authority, your lordship.
And against that, madam, the summon was issued, and that summon has been challenged by way of this civil revision petition.
okay.
Madam, the accepting the submission, madam, since the matter is pending before, madam, this can be reverted back to the appellate authority, granting the petitioner to raise his grievances before the appellate authority.
Okay.
This can be, this way, this can be, madam. Respondent, madam. Respondent here and appellant in the appellate court before the civil judge senior division.
Okay. So this is, since this was in the oral column, I did not go through. Anyway, so we'll come, huh? I'll record the fact and then the pass the order, huh? Okay. So this, basically this is challenged, okay, hard miss. Okay, come, huh? Now the council for the petitioner. Stop. I have also heard Mr. Tobun, Tidabun, land council, the sole respondent, stuff. Fair. Fair. This is an application. So by filing this application under Article 227 of the Constitution of India, the petitioner sought for setting aside and quashing of the order dated 12/9/2023 issued by the head Gamburi of Mirku village, Mirku MIRKU village, by which the said head GB has authorized 1/3 Obok Dupak GB to conduct Kebang So you are challenging two documents.
orders, your lordship.
One is this order and
One
one
is-
is summon.
One is
Summon
summoned.
dated
Okay.
12/9.
September
The
2000.
petitioner has also challenged the summon dated 15/9/2023 issued by the GB of Mirku village. So what is, and Kaban to be held, this is the another,
Yes, another press, madam.
This is
this Kaban to be held on, what is this?
26
On
September.
It is in the said summon only, I think this has been mentioned.
Yes, yes, yes.
Okay, okay.
This has not been acted upon, madam.
Okay.
Yes, there's still interim order.
yes, there's an
Okay, that's. Stop. The case of the petitioner is that what is the earlier case you said? which is under challenge, which is pending before?
My lord,
Where have you stated?
my lord, it is
Which is pending?
before the civil judge, senior division.
Where have you stated? Para?
The case number will be, your lordship, if.
Pleading,
sorry,
pleading.
Pleading.
In the pleading, or where have you annexed the document? Showing that the case is pending before? The similar matter,
Yes, your lordship.
the same case,
It is at Annexure 4 series.
annexure 4
Page-
series.
My lord, the appeal is an additional affidavit, your lordship.
Additional affidavit you have.
Yes, your lordship.
Why? Additional affidavit? Oh, it is there. Okay.
Annexure B, your lordship.
Hmm?
Annexure B, additional affidavit, page number 7. My lord, this was the case pending before the deputy commissioner, and this case was transferred before the court of district judge, your lordship, which has been renumbered as Pasigat Civil Kabang 63 of 2022.
Just a minute, huh?
Affidavit, additional affidavit, para 2, my lord.
Okay. The case of the petitioner is that the Keba has already been held on the same issue, and the decision was rendered on 25/2/2020. Who filed the complaint first initially?
The
Respondent.
respondent, your lordship.
Okay.
And the Kaba was held on 25/2/2021. your lordship.
The complaint was about what? Have you
Regarding-
annexed the complaint? Have you annexed the complaint?
It was regarding land dispute, your lordship.
My lord,
Okay.
complaint is at page 30, madam,
Of
Page 30 of
of,
the
of
CRP.
the CRP, madam.
30.
Yes, madam. Translated copy is page 30, madam. Dated 11 February 2021.
Okay, leave that. The case of the petitioner is that the respondent, you have filed the complaint.
Yes.
Respondent lodged a complaint before the GB.
Yes, your lordship.
Head
GB, ma'am.
GB Marpu Village
Ma'am.
Council. Pasigat,
My lord.
complaining what?
Complaining,
Regarding
my lord, certain landed property, my lord,
Hmm.
on the ground that, my lord, this appellant, my lord, respondent before the Keba, my lord,
Hmm.
he started claiming on the ground of performance on the ground that he had performed the last rites of the forefather.
Complaint against appellant. Claiming landed properties. So you claim landed property from the appellant.
Yes, my lord, appellant, this is in fact the land belongs to the, as per inside, land belongs to the respondent actually. Hereditary, my lord, ancestor belongs to, this land belongs to the respondent.
Hmm.
So on the ground that he has performed, the appellant, that is respondent in the the appellate court, my lord. He has performed the last rite. There's a traditional custom.
Who
in the-
performed last right, he is entitled to inherit some.
Yes, yes,
portion
yes.
of land.
That
Okay.
is, now there's a dispute, my lord, that is, he has also performed the last rite and I have also performed the last rite. So that last rite, the rite that has been set off since we together performed the forefather of the two, my lord. So that this issue, my lord, this is the basically, that's why this confused arose, my
And
lord.
then this
last
claim is from whom? The land claim is
From the respondent, your lordship. Respondent hearing, he had filed a complaint before the Kaba, your lordship,
Hmm.
against the petitioner.
Okay.
And pursuant to his complaint,
Hmm.
a Kaba was held on 25/2/2021, your lordship. And the
The respondent claiming land from you.
no, respondent claimed, the claim of the respondent was that the petitioner was claiming the landed properties in his favor, your lordship. That his claim was that the properties belong to him, but the petitioner hearing, he had claimed the landed properties to be his property, your lordship. That was the complaint before the cover.
And basically, this is, my lord, only on the ground of performance of last right only. So this, if last right, this can be taken up, raised before the appellate court, my lord, since the appellate court is examining.
Okay. So, against the petitioner, claiming some land, So, the Kema at Mirku village has settled the matter by passing a judgment. By passing the following judgment, then we'll type the judgment here.
Yes.
Kema, okay. So for understanding, I'll reduce it later. So judgment is here.
Annexure
Page
3,
2.
page number 37.
Since, my lord, just
agreed by the said judgment, the petitioner.
No,
the respondent
Respondent
filed
filed
the appeal.
appeal before the
district judge, deputy commissioner.
Initially before the deputy commissioner, before the
Initially
enactment.
before the deputy commissioner, the deputy commissioner has transferred the said appeal before the district
District
judge
My lord.
Pasigat,
Yes, your lord.
and thereafter the district judge has endorsed the same to the civil judge senior division Pasigat. So while the said appeal
Was pending.
is still pending before the civil judge senior division Pasigat, the respondent filed another complaint. Where is that complaint?
At page 41, my lord, of CRP, my lord. 12 September 2000. Translated copy.
My lord, this is by the head Gaumburi, your lordship, transferring the matter to the head Gaumburi. The complaint is not annexed here.
Hmm?
The complaint is not annexed here, your lordship.
To GB, the one handling about the Gaumbura.
This
No, this is not a complaint.
No, your
Page
lordship.
41.
complaint
your
they have not annexed, my lord.
Complaint is not annexed, your lordship.
This is endorsement, my lord.
We didn't
This is
receive a
endorse-
copy of the complaint, your lordship.
You have the copy?
No, your lordship, we did not receive a copy of the complaint. All we received was this letter, your lordship.
Okay, the complaint. How do we know what was the content of the complaint, said complaint?
My lord, we are also not aware of the complaint, your lordship. Only, we had received a copy of this letter, your lordship, and the summon issued by the head Gaumburi.
So but in the said complaint, it raised the same issue,
Yes, your lordship.
raising the same issue which has
My lord, last right. Basically, the issue is last right.
settled by the GB. The said complaint was endorsed. Complaint was before the GB Mirku village, raising the same issue which was already decided by the Kabang.
By the Kabang, yes, your lordship.
My lord.
Okay, the said complaint was endorsed to Gaumbura Mirku.
Yes, Your Lordship.
Then,
Then at page number 43, Your Lordship, translated copy, the Gambura issued summons to the petitioner. Your Lordship.
okay, basing on the said complaint, basing on the said second complaint, the GB issued Keban summons. GB customary court Mirku village issued a Keban summons to the petitioner. Which is under challenged before this petition. And what else? The other one is, this is also Keba summon.
No, Your Lord, there's only one Kaba summon.
Okay. And what was the other?
It was the letter issued by the, written by the head Gamburi to the Gambura to take up the Kaba, Your Lordship.
Okay.
12-9, that was the letter issued by the head
Yeah,
Gamburi. And 15 is the summon.
It is, it is submitted. That is the matter. So you say that there are some some points which could not covered. In
Yes,
the-
yes, yes, man. The
That can be
specific,
covered.
the point of last right, man.
Hmm.
Although in initial complaint it was mentioned, but the Keba, while deciding this, the point has not been.
Where do we find that?
But the last right, Malu, see.
No. Which was in the earlier Keba, it was not covered.
Yes,
So
madam.
now the present complainant want that this point also should be incorporated.
Malad.
Where do we find that?
Malad, page 30, Malad. Translated copy, Malad. Translated copy, Malad. Paragraph 2, madam. Last sentence, madam. Legal notice on show.
Page 30.
Yes, madam.
After receiving my legal notice.
Sure. And property.
According to the legal. No,
Yes,
this is
perform the last right of servant, madam, of role of man. Now, this, although we have, this, despite of this, all the issue and the landed property, the Keba decision at page 37, madam. This, all the aspect has not been considered in Keba decision. Madam. That's why it was challenged, madam. So, madam, basically, madam, because of this, the appeal was preferred, madam. So that's why my subsequent, madam, they was
okay, since the, it is submitted that since the decision, since the this matter has already been decided by the
Keba
at Mirku village.
Without considering, my lord, the issue on last right.
25 February 2021. No? It was, no, when it was decided,
On
Keba?
25 to 2020.
25 February 2021, page 37. On dated first sentence.
And the same is under challenge, same has been challenged, and which is pending, a challenge before the Learned Civil Judge Senior Division, which is still pending. The matter can be referred. No?
Yes, madam.
Matter can be referred.
Remanded back.
No, remanded back to. It will not be remanded back. It can be remanded.
Yes, madam.
Kaba has been held. There is an appeal pending against it. There cannot be any recover.
No.
Appeal is already pending. Let the senior division decide the appeal. There is no point of raising the last right and all these things here. That will be decided.
No, that will not be raised.
Yes.
That cannot be raised.
There is no
because
point of remanding back. These two, some orders.
It cannot be.
Yes.
After saying, madam, only my humble submission, after allowing this matter, only liberty may be granted to the petitioner to raise all his relevant issue before the appellate court. Madam, that only observation may will suffice.
Okay, since the
only issue there
challenge and pending before the Learned
That is
CJM.
fine.
Sorry, Civil Judge Senior Division, there cannot be re-Keban on the same matter. To adjudicate on the same matter which has already been decided. The Learned Counsel for the respondent has fairly submitted, fairly considered that the matter has already been decided. However, some of the points which could, some of the points could not be raised in the earlier Keban. The second complaint was lost by raising some additional points and additional points which however can be incorporated in the complaint, incorporated
Before the
you
appellate
wanted,
document, just
before, which however can be raised before the appellate court. In view of the above, the where is the impugned order?
At page number
page 43, madam.
40.
Page number 40, it starts with page number 45 series.
Okay. And as agreed upon by the parties, the impugned order dated 12, Keba handing over. This is handing over
Yes, Your Lordship. This will be the.
or someone?
No,
What
Your
is
Lordship, this
someone?
will be the letter, Your Lordship, or communication, dated 12/9/2020.
Impugned Keba impugned order, impugned, this is not order,
No,
it's
Your
not,
Lordship,
it's a letter.
communication, Your Lordship.
Impugned letter dated 12/9/2023, by which 12/9/93, issued by the head GB Mirku, Dapi, Pasigat, and which one is it? Which
The
is-
other is at page number 42, Your Lordship. This is the Kabang side.
and the Keba summons dated
15/9/2020.
15/9/2023, issued by the GB Customary Court, Mirku Village Council Authority, is hereby sets aside. Stop. Liberty is granted to the respondent. However, liberty is granted to the respondent to raise the new issues, if any, before the appellate court. With the above, this application stands allowed and disposal. Okay.
Declare.
I'll modify the
Right.
order accordingly.
Of like-
Yeah.
Yes, ma'am. For the appellant, Your Honor.
Yes.
Your Lordship may allow to take dusty service upon respondent number 2 and 3.
Affidavit, not yet filed.
Pardon?
You have taken that steps by dusty service.
Yes.
Have you filed affidavit? Not yet.
No, I'm for the appellant.
Oh, you're for affidavit.
Yes, yes.
So that is what I'm saying. You were to file affidavit regarding dusty service.
Yes, sir.
Have you filed?
Yes, Your Lordship.
Okay, where do we find?
Your Lordship, respondent number 1 has appeared and we still didn't took any dusty service upon respondent number 2 and 3. So
Lordship may allow to take once again the step upon respondent number 2 and 3. To Dusty Service.
Some sound disturbance. Respondent
Number 2 and 3.
2 and 3.
Yes, Your Lordship.
So you have taken step by way of dusty service upon
Yes.
respondent number 2 and 3.
No, Your Lordship. May allow to take again re-step, Your Lordship.
Hmm?
Re-step, Your Lordship. Fresh steps. We want to take fresh steps.
So you have not yet taken steps. Not yet taken steps.
Yes,
The
Lordship.
office note says learning counsel for the petitioner has not yet filed affidavit regarding dusty service of notice in respect of respondent number 2 and 3. You are supposed to have already taken steps upon them by way of dusty service. You have not yet taken.
Not yet taken. So we'll take fresh steps again.
Okay. You are praying for some more time.
Yes, Lordship.
Okay, Mr.
B. Dulom.
Learning counsel for the petitioner prays for and is granted how much time?
2 weeks.
2 weeks time, 2 weeks more time to take fresh steps upon the respondent number 2
2
and
and
3
3. Yes, Lordship.
by
Dusty
dusty
service.
by way of dusty service. The prayer is allowed. List this matter after 3 weeks.
2 weeks, Your Lordship.
2 weeks.
2 weeks.
Will it be done within
Oh,
2 weeks?
yes, yes, Your
Okay.
Lordship.
Where is the respondent used to stay? Okay, this is after 2 weeks.
Okay, obliged.
Yes.
Your Honor, in this case, I'm appearing on behalf of Mr. S.K. Deori.
Hmm?
I'm appearing on behalf of Mr. S.K. Deori. He's a
Yes.
counsel from Guwahati, Your Honor.
Okay,
So, because they could not be present here today, the matter may be fixed after 3 weeks.
after 2 weeks.
But,
Okay.
Your Honor, it appears that the service is still awaited or steps have not been taken on respondent number 2.
Oh,
that
yes.
state.
No, they're taking fresh steps.
So we may be
Hmm.
allowed to take fresh
Okay.
steps, Your Honor.
You are for.
And Your Lordship, I'm for the respondent 1. And Your Lordship, I appearing on behalf of Mr. Ofada, special PV for SIC. And I have been instructed to inform before this honorable court that there is no further instruction from the SIC. So
There's
no further instruction from SIC.
okay. Anyway,
And Your Lordship, the matter may be fixed after 4 weeks, Your Honor.
after
4 weeks.
4 weeks. Okay. Miss
T.Y. Bhutia,
appearing on behalf of Mr. S.K. Deori,
S.K. Deori.
learning counsel for the petitioner, and Miss
I'm Likha.
Likha, appearing on behalf of
Mr. Ofada.
Mr. Opada, SC.
SIC.
Staff. Miss. Her name, Miss, appearing on behalf of SK Deori, prays for and is granted further 3 weeks time to take fresh steps upon the respondent number 2. Respondent number 2,
Respondent number 2, Your Honor.
only 2.
Only 2.
Okay, start. List is prayed for by. The respondent, the step shall be taken upon the respondent number 2, and the prayer is allowed, The petitioner shall take steps upon the respondent number 2 by a register post week 80 within a week from today. Start. List this matter after, is prayed for by the land council for the party. List this matter after 4 weeks. Okay.
Oh.
Yes.
Your Lordship, leading counsel for petitioner is engaged in the other court. May I humbly pray for Passover?
This appeal is against your lordship order and judgment in,
Okay. 13.
yes, 376, yes.
Okay.
IPC.
list this matter before appropriate court without me. No?
Yes, exactly.
Okay.
Obvious.
So, name will be. Okay. Just a minute. Huh? Just a minute.
Ma'am, hello.
Just a minute.
Item number.
Just a minute. Huh? What was this? Okay. Yes.
Item number 14, 15, 20, 27 and 28 may be taken up together, Your Lordship. This, the IA has been filed in both the cases.
Okay, 14, 15.
And 27 and 28 IA.
27 and 28.
Yes, Your Lordship.
Okay. Okay, so
If
let
you-
us one by one.
Yes,
Let
Your
us see the item 14 first.
Your Lordship, before my brother start, Your Lordship, I will clarify everything, Your Lordship. The IA has been filed for implement of the informant because, Your Lordship, they have challenged the bail cancellation order
Okay.
passed by the learned court below in NDPS case,
Hmm.
which has passed in a mechanical and a cryptic manner by the special court.
Okay.
And since they have approached this court by invoking 482,
Hmm.
as per the High Court rule, implement of the informant is
Right,
obligatory.
right.
So for that, they have filed the IA.
This IA.
Yes, Your Lordship. In both the cases.
For implement. IA 27.
Yes, 27 and 28.
Okay.
Oth-
Okay.
Otherwise, Your Lordship, in item number 14 and 15 is a common order passed against two accused.
Okay.
Both the accused.
Hmm.
Wherein, Your Lordship, there are basically three criminal cases pending, the NDPS cases. In first NDPS case, bail was granted, and subsequently in second also the bail was granted. In third NDPS case, both the prior, Your Lordship, the bail application was cancelled. It was supposed to be cancelled on the respective cases only. But in the third bail application, the former both the this bail has been cancelled by the learned special court, Your Lordship.
Okay.
So for that they have challenging that is one aspect they are challenging, and second is they have not been afforded any opportunity to Your Lordship to opportunity of being heard because it was the case was pertains to cancellation of bail. So basically this is the case, Your Lordship.
Notice.
Yes, Your Lordship.
So what we want now? Which?
Your Honor, my lord, this matter may be disposed of today. Because on the last occasion, the LCR was called for. Since I'm languishing in jail by the cancellation of my bail order, 12/9/2023, I was languishing in jail. Only due to cancellation of death order. So, my lord, I only pray that this matter may be disposed of today.
Okay, let us see first. Implement already implemented.
Implement
For the
is
past?
for the first time the implement petition is before Your Lordship.
Okay.
The
Not yet
IA.
implemented.
Not implemented earlier. This is
Okay.
for the first time.
My lord, however, the informant is a police officer itself. My lord, therefore,
Okay.
PVP is here to represent the police informant. So, the informant itself is a police officer. I am. It's inspector.
Well, record has come.
No, LCR not received, Your Lordship. LCR was called for, Your Lordship, earlier, but it is not with, LCR will be through registry only, Your Lordship.
So it's a noted come.
Yes, Your Lordship.
What is this?
That is the matter, last order, LCR.
Yes.
So now, Your Lordship, what my humble submission would be, Your Lordship. Your Lordship may kindly dispose of this item number 27 and 28, first IA. Your Lordship may, whether Your Lordship convinced to Your Lordship implead the informant. If the informant is impleaded, Your Lordship.
IA. This item 27. This is IA. This is 38. 27. Okay. Who has filed this one? IA? IA filed by you?
Yes, yes, I have taken. For implement of informant. Respondent number 2.
So they are necessary party.
Yes, Your Lordship. They may, we don't have any objection if the informant is impleaded, Your Lordship.
Or Mr. T. Taggu, Learned Counsel for the applicant. And Mr. Learned Counsel, additional PP. This is an application under section 482, praying for increment of 482 CRPC, praying for increment of he is informant.
Yes, informant.
Okay. Informant. Inspector Otto Gao is respondent number 2 in the connected criminal petition number 18 AP 2024. And 2024 is the is he was the informant of the case. So you have no objection?
No objection, Your Lordship.
Okay, the land additional PP has no objection for implement of the informant as respondent number 2 to the criminal petition number 18 AP 2024 stuff. In view of the above, this petition is allowed. The the Inspector Otto Gao write this address, stands impleaded as respondent number 2.
2, yes.
Yes.
Okay.
The registry shall do the needful to incorporate the name of the respondent number 2 in the main appeal. With the above, please. I stands disposed of. Both are
And 28,
similar
again,
order, I think.
yeah, 20 and 28, they've filed a separate I in bail, criminal petition number 19, same order, Your Lordship.
Okay, same order, huh? And in the main? Hmm? Okay, this is item 14. Okay, in item 14, so the case record is still awaited.
Both the cases were recorded awaited, Your Lordship.
Okay. In the main case, huh? Hard Mr. His name, huh?
My lord,
So,
short date, short date may be given, my lord,
Okay,
since
sir.
I was in jail
Hmm.
from 12/9/2023.
Okay.
The fixed date may be given.
Also hard Mr. Huh? Then additional PP, huh? Stop, huh? Then the case that is sorry, record is called for is still awaited.
LCR.
Is LCR? no?
Yes.
LCR.
Okay, LCR is called for is still awaited. The Lanet additional PP, pray for some more time. to produce-
Your Lordship, this record has to be produced through Your Lordship registry. Your Lordship, it pertains to the cancellation of bail exercised by the London Special Court, and
Okay.
record has to be routed through Your Lordship registry.
Okay. Okay, then leave the last order, then issue reminder. So sorry, the registry is directed to issue reminder. Because it was also directed to the registry to take steps. Hmm?
Yes, Your Lordship.
The registry is directed to issue reminder for calling of the record from the Lanet Court of NDPS Pasigat. A special court NDPS Pasigat, East Siam District. Okay. List this matter after.
My lord, on 9 of this month. My lord, it's from
Okay,
Pasigat.
is prayed for by. The 9, then on that day, if the record doesn't arrive, then by then. It
My
was
lord,
difficult.
My lord, on earlier, okay, on last occasion, on 16/2/2024,
Hmm.
on last order, my lord, LCR was called for, but they voluntarily, they are not sending the LCR.
Yeah, now they will send.
And Your Lordship, one more issue is there, Your
For
Lordship.
that
Since
reason, I'm linguisting in jail. Voluntarily, they are not sending the LCR.
Your Lordship, no doubt they have a good case, but procedure part has to be complied with, Your Lordship.
Yes.
And secondly, Your Lordship, since the IO has been implemented, respond number 2, notice has to go, Your Lordship. So
My lord,
they may take steps through registry, Your Lordship, and we can, you know, communicate it through, we can communicate through
lord,
Office of Public Prosecutor, Your Lordship.
Okay. So here, do one thing, in view of the order pass in the IA. (2024), huh? In this 2024, the petitioner shall take steps upon the newly implemented respondent number 2 by a registered post with AD within a week from today.
Within 2 days.
List within 2 days. Huh? List is matter after 3 weeks.
My lord, 3 weeks is.
Now you have to take steps also.
My lord,
Uh,
fix that.
step, and then the record has also not yet come. If you want, we can say.
My lord, it may be fixed on 22.
22?
Yes.
Will it be done?
Lordship, let it be on 23rd. If no update come, then.
Is paid for by Telangana Council
23rd,
for the
huh?
party. This is matter on 23rd
Yes, Your Lordship.
April. Huh?
Deeply obliged, Your Lordship.
Same.
Item number 15 is same.
Same.
Same. Deeply obliged.
This,
Yes.
RFA is directed against the judgment dated 7/12/2015 in title suit number 7 of 2012, which is at page 88, my lord. Before I take my lord to the impugn judgment order, for brevity of the facts, my lord, kindly come to the memo of the appeal. It is only 3-4 pages, my lord. My lord will have the memo of the appeal, that is better. Memo of the appeal. The
How will
paper-
respondent?
Paper book. One.
Only one. Okay, so respondent.
My lord will come to page 156.
156.
155 onwards, it is.
Yes, 136. What is this?
155 is the memo of the appeal against that impugned judgment.
Okay.
Just I'm referring this first, my lord, instead of taking to the impugned judgment for the facts. My lord will come.
155.
Yes, yes. RFA only.
155 is something else. It appears.
This is RFA only.
Ours is different.
RFA 1.
Yes. But 155, ours is different, something else.
155 is something else.
Something else. Internal page is 3, my lord, isn't it? Yes.
Yes.
My lord, I'm having this book only, brother.
This is some affidavit.
Yes. The memo of appeal.
Are we with the same paper book?
Yes.
Memo of appeal 92 to 99.
No, then it is a wrong thing. There is 155. Look the same.
Memo of appeal is
155 to
92.
Yes, 92 to 99.
My lord,
So extra, isn't it?
my lord, it is not my fault.
Yes.
Maybe this can be, registry can furnish a correct copy, my lord, for the next day, so that can be disposed. This is correct.
That is correct.
That is correct.
Yes.
So have the correct copy then.
Then I'll have the correct copy. I'll request Brother Pangin to accommodate me any day after this thing.
Can it be on 23rd?
Okay.
Because the dispute has been going on since 1991.
Yes, it appears. Old case.
The original plaintiff has died. My husband has died.
My lord,
In such a situation.
yes, when I go through the entire brief, I also felt very bad. Since this is an engaged case from one of our friend from Pasig.
Okay, there is prayed for by the Lana Council for the parties. List this matter on
23rd. 23rd of April.
Convenient to my brother Pangin.
23rd?
Yes.
Okay.
And
My lord may direct the registry to furnish a
requested to furnish the
Okay.
paper book.
the paper book or
Okay.
the corrected paper book. To the
The registry
to the appeal.
is directed to corrected paper book. the paper book. Directed to furnish a correct paper book of RFA number 1, AP 2016 to the Lana Council for the appellant.
List on 23rd. Interim order to continue with that.
The interim order passed earlier shall continue till the next date. Okay.
Okay. Okay.
Yes.
Wait, Lord, but this is jail appeal
Okay.
against the judgment and order.
Okay.
I am appearing as a amicus curiae.
Okay.
The appeal is at page 76
of the paper book.
Paper book.
Okay. Yes.
So, my lord, after going through the contents of the appeal application, and also after going through the contents of judgment, my lord, prima facie there is no any case against the accused person.
Okay.
The accused person is languishing in the jail for unnecessary for 8 years.
8 years.
8 years. He
was
in jail.
convicted for what offense?
Offense, sir, my lord,
Let us just see the judgment once.
Judgment is page 31, madam, from
31.
31 onwards. But practically there is a mechanical factual incorrect.
That's incorrect.
Yes. There is no any medical report. Medical report is there, but no any evidence of your injury, no any mark of your some sexual assault.
This FOXO or just
376? 376. And
The
read with
FOXO also.
section, read with
Section
section
4 of
4.
FOXO also, I think.
Read with
Also, around 2 hours for journey with escort team. And here it's very much clear that not fit to keep in custody.
Okay. Mr. S. Chaudhary. S. Chaudhary, Lana Council for petitioner. Staff. Also, I've also heard Mr. G. Tado, Lana additional PP. Staff. This is an application under section 439 of the CRPC 1973, praying for grant of bail to the accused. What is the name of the accused?
Ansuman Doimari.
Ansuman
Doimari.
Doimari, who has been arrested in connection with Balupong PS case number 01/2024 under section 20C, within the C, stroke 25 of the NDPS Act 1985. Stop. The case of the petitioner is that it was after arresting them, or I think probably thereafter the FIR was filed.
Yes.
Okay.
arrested on 18/2, my lord, and after arrest, on the same day.
Okay. The case of the petitioner is that basing on the FIR lodged by one Jambesari ASI P within bracket P of Bhalopong, the case was registered in the above PS case. The case was registered being Bhalopong PS case number 01/2024 under section 20C 25 NDPS, and the accused named Ansuman was arrested on
18/2.
18/2. 18/2/2024. Stop. By filing this bail application, the applicant is not praying for release of the accused on praying for release of the accused on merit. The prayer for release of the accused is on health ground. The accused, so the petitioner has produced annexed the medical document where is the statement that he is suffering from? Where have you stated,
my lord? Para 5, my lord, page 6.
Okay. Okay. The learned counsel for the petitioner submits that the accused is a patient. What patient?
Kidney patient, my lord.
Having both his kidneys damaged, and at present he is on constant dialysis. That's twice a week. So once in a week.
They are doing once in a week, but has to be done twice, madam. That is another thing. Once they are doing once in a week.
And now stop. After his arrest, the accused was taken to Apollo Hospital at Udalguri. After arrest?
Yes, after arrest, he was immediately taken to Udalguri, madam.
Udalguri
for dialysis.
Dialysis on the it was
on 22nd.
It was on the direction of the court.
No, it was direction of the OC of
the
jail.
accused was taken to Apollo Hospital at Udalguri for dialysis, and thereafter the accused was brought back to the judicial custody staff. At Bomdila. Under the circumstances,
page 29, my lord. See the data.
Annexure,
Annexure, my lord, this is
the medical document is annexure,
5 collie,
5,
collie,
okay.
page 29, my lord.
Hmm.
This is dilution done on first one at Udalguri, my lord. Apollo
I have
Hospital.
perused the same, stop. Para, Basing on the above documents, the Learned Counsel for the petitioner prays for release of the accused on health ground in order to facilitate proper treatment of the accused outside the jail cell. Para. Para, So, while calling for the case diary, this court by an order dated this court on 5/3/2024 also directed the jail authority where the petitioner, where the accused is now detained. Jail authority, huh?
Jail authority, my lord.
Jail authority of this is Bomdila, I think.
Yes, Bomdila.
Directed to forward the report regarding the health condition of the arrested accused. You have also produced the case diary? This is
Yes,
case diary.
yes, I have
And then this is from jail authority. Same.
No, I've submitted the
Yes, yes.
case diary.
Yes, yes, yeah. This is received today only. Okay.
That is through registry.
Okay, through registry. Mr. Taro Lanet, ADPP produced the case study and I perused the same. Case study, huh? The record regarding the health condition of the accused has also been forwarded to the registry of this court by the in charge of UTB cell at Bomdila, which has been produced. And then I have I've also perused the same stuff. That. As per the record, so the accused is directly involved, directly or in?
Directly involved.
Okay.
Uh,
The accused is the main.
Directly involved in financing and transporting
The accused involved in financing and transporting
of the cannabis.
of the cannabis.
210 kg seized
uh,
cannabis.
Cannabis and From
And
whose
on
possession?
earlier occasion also, he was involved in same nature of offense.
Other case also? Okay.
In
He-
earlier also, he was involved in same nature of offense. He admitted in his statement that twice he was involved in similar nature of
Okay.
offense, but
Ah.
on fourth time he was caught.
He is also found to be involved in some other similar NDPS cases.
No, not other involved in, he said that he done such kind of thing maybe, but not involved in NDPS cases. This is the first time he's caught.
No, one
Okay.
statement of the
And,
accused,
and
it is there.
in the instant case, how many cases you said?
3 cases earlier, he was in similar nature of case involved.
No.
And in fourth time he was caught.
No.
This
okay,
in this case is his fourth.
Okay, okay. Involved and found involved in another case. And in the instant case, how many kgs of the material was recovered? In the instant case, present case.
In present
How
case,
many kgs? Kg.
210 kg.
Okay, in the instant case, 200 kg of what? Where it is mentioned?
Cannabis, FIR.
Cannabis has been recovered from the possession of the accused persons, no? Which comes under the commercial quantity.
Quantity.
And the punishment for and the punishment for which is life.
Yes, if commercial quantity is there, it's like
Not less than 10 years, madam. Not less than
10 years.
10 years.
And may extend to
20 years.
20 years. With fine of 1 lakh. No?
Madam.
Okay, start. Fair. The as per the health, as per the
yes.
report regarding the health condition of the petitioner, sorry, the accused. The accused he is, where do we find that he is suffering from? Accused Ansuma Doimari, huh? As per the report regarding health condition of the petitioner Ansuma Doimari, a health screening was performed for what? Health
Screening is generally done by the medical officer of the jail.
Generally done by?
Medical officer of the jail.
Okay. So probably it was done.
It's like a routine checkup.
And they confirm that his kidneys are damaged. And this is, I've annexed it also, madam. This is the, I've annexed it also, the middle.
Page perform health screening of the prisoners. Was done before lodging the arrested accused into UTP cell. And during the screening, it was found that the accused was suffering from kidney failure and was under dialysis. Stop. Accordingly, on 28/2/2024, the EMO of General Hospital Bomdila, Bomdila, referred the accused to Dialysis Center Dirang for further management. And on 29/2/2024, the accused underwent dialysis. So, and a wide medical examination report dated 9/3/2024 the wide medical examination report dated 9/3/2024 prepared by the medical officer, Community Health Center, Dirang. Also, it is reported that the accused is suffering from chronic kidney disease, which needs weekly maintenance of hemodialysis. So, and following the advice, petitioner was taken to CHC, Dirang for dialysis on the same day on 9/3/2024 and on 16/3/2024. And the next date for dialysis is fixed on 23/3/2024.
This, this report was sent on, prepared on 21st March.
Right.
Thereafter also, I've been to be informed that thereafter also they took the
on 23,
26, and another
and it is
two more
reported
occasions.
that it is reported on the 23 and on 23/3/2024 and on 26.
Yes.
26/3/2024 also.
And the next date on 6th of this month, madam.
The accused was taken to Dirang for dialysis is the said provision is not available at Bomdila.
Yes, not available at Bomdila.
At Bomdila. Stop. And the next date for his dialysis is fixed on 6th month of April 2024. Where we have seen earlier one document where it says that is not fit to be kept in.
My lord.
It is in petition.
Petition, my lord. Page number 21, my lord. The medical report by the senior medical officer. Annex 3, page 21. Down below, my lord.
Okay.
Issued by
this was,
CS.
this was in the initial at the time of arrest.
Yeah, absolutely.
Okay. The record also reveals that at the time of arrest, during his medical examination, the doctor, while finding that he is, the accused was
Kidney patient.
a kidney patient had kidney patient had kidney patient for which he was undergoing dialysis treatment had also suggested that suggested in his remark that the accused is not fit to be kept in lockup as he needs specialist intervention. So, okay. Sarah, huh? Considering the gravity of the seriousness of allegation and the gravity of offense committed by the accused, and the material found against him on record, I am not inclined to grant bail to the accused at this stage. However, considering that the accused is a chronic kidney patient for which he needs a regular dialysis twice in a week, from the other health problem that he had as shown in the records, I am of the view that the bail prayer of the accused can be considered for his release in order to facilitate the proper treatment for his disease. According to this bail application is allowed on health ground. The accused is directed to be released on bail on execution of a bail bond of rupees 50,000. No, it is NBS 1 lakh. No?
Yes,
It's 1
NBS.
lakh, 1 lakh with one surety, sorry, with two sureties of like amount to the satisfaction of the learned district session judge. So special judge. Special judge. Bomdila, with the following on the following conditions that he shall, where is the CPC? So basically he is from which place?
From Orang,
Huh?
Udalguri.
Udalguri is
And Udalguri is Assam, Mali.
Nearby Tezpur? No.
Nearby Tezpur, Mali.
Okay. So, but given this treatment, I think he can report there from time to time.
Sure, Mali.
That
We are planning for kidney transplantation. If it's
then
success, Mali.
then you obtain permission from the court.
Yes, yes.
For the long period of
Sure,
treatment, etc.
Sure, Mali.
Okay. That should also be one in his submission, one sentence the learned counsel for the petitioner Parasami said that the accused need required to be
kidney transplantation for his survival, my lord.
means kidney transplantation.
My lord.
For which his father is ready, for which his father
Father is ready to donate one kidney.
Kidney. Okay. Okay, in the condition that the accused shall make himself available for interrogation is over only, I think. For interrogation by the police or by the IO agent when required. 2. That the accused that he shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or to any police officer. That the accused shall report the IO of the case once in a
month it will be better for such a kidney patient, my lord, at least, because
once in a month,
my lord. Whenever the IO calls, my lord.
Once in a month, my lord. On 15th of
Yes.
15th, first Monday of the second week of every month, for 3 months, my lord. And agent when called for the IO. That is also there. What more, what else?
That will do.
I think that is enough.
Yes.
Okay.
One little correction. Quantity is 220.74 kg, not 210.
Correct kg, huh?
220.74 kg.
With the above, with the observation made above, this bail application stands allowed and disposal. Okay.
Deep problem.
Obviously.
Yes.
Yesterday's
case.
Appellant part, he has completed his
Okay.
argument.
Ah.
So my part here.
But then, how the condition would be like, say, because if the construction is allowed, and probably, of course, it amounts to, of course, it cannot, the clock cannot, of course, turn back.
No, my lord.
No, no,
Here
just,
is-
just
yes, yes.
I'm asking.
Yes, yes.
So, if it is allowed, then you take advantage again. So entire lane is not much, then it's 9,000, but then it appears that the entire, almost all the lane covered by the building, it appears from the photographs.
Yes, yes. I will,
Ah.
my lord may put the call.
So how would be, supposing if the petitioner, if the case goes in favor of the petitioner, how the compensation would be?
Yes,
Like,
yes.
the conclusion means, I mean, the.
Yes, first part is, my lord, first part is like that. The three principles are there for granting the.
No, that is true. There you
So
see,
basically,
of course,
I will
it
come to that.
tilted towards, of course,
Yes.
everything, of course. in your
Everything
favor.
is my favor.
Ah.
So generally, what the law says,
Yes.
because unless a person is not in possession, because admittedly, it's under my possession, no dispute.
Ah.
So law says that when there is no possession,
Ah.
because there is a presumption of ownership is on me. Now, there is the law says that when the person is in possession, there, section 110 of the evidence act, automatically presumption comes, he is the owner of the land. And moreover, in my case, LPC also with me. I will deal with all aspects. Now everything is and since last 1 year,
LPC, the earlier LPC, of course, cancelled.
it is cancelled, but they have put into challenge.
2003.
Mothers.
2003 is still under challenge.
Now
Suppose if-
suspended.
Just a minute, just if that succeed, supposing if that succeed, 2003, because they have already challenged
Right.
the cancellation of the LPC of 2013 in favor of the petitioner.
Right.
If that succeed,
That's why.
because every
Yes.
possibilities are there.
Yes.
Let us see. So just give.
Here, Your Honor, now the issue is like this, I am in the possession of.
Hmm.
Since 1 year, I've been constructed.
Right.
Now the law says that, because in the situation, I will show the judgment, series of judgments Supreme Court. When the person is in possession, he has already commenced the work. No injunction. How injunction can be given? Otherwise, what will happen here tomorrow, Your Honor? If we accept their proposition, what is the dangerous thing I can file title suit against anybody's property. What is the big deal, Your Honor? I can come with so many stories. I can file that, oh, I have a title. I will raise the title dispute.
That is true, but here the
Let's-
case
let's-
where-
let's assume.
See here are
No, I will come to that. Then in that situation, what will happen? Because in that way, how now balance of convenience is in my favor. How
Yes.
I will be deprived? Because for so far the plaintiff is concerned, he will get the land, he can recover land. Land will not go anywhere. You don't know, because ultimately I will suffer. Land will not go anywhere. And law says that during the pendency of the title suit, any third party even say not valid, doctrine of least pendis. So he will get the land back. He will not suffer anything if he wins. But how I will suffer? My right to enjoy property. I have put already money. I have taken loan from the bank. I've been paying interest. So suppose if I win tomorrow, how all these a title suit will take minimum 4 or 5 years to decide. Now these 5 years, I will be deprived of using my right to
Yes,
property.
that is true. I understand.
Yes.
So what I'm saying is my query is only if if they win.
They will
So,
get the land.
because if you are allowed to
Yes.
construct
Yes.
or complete the building.
Yes.
So the
This will be on my period. That will be damage on you. Because once land is, suppose title is upheld upon them, definitely they will get evicted. They can easily get evicted against me. It is not something, my lord. because
now
I-
you would not be claiming any compensation for the
No,
building.
how can I? How can I?
Okay.
How can I?
Okay.
Because once suppose land is gone means they can they have the prayer for the recover of the possession of that. Land will go there and they will say you evict the debt structure. How can I claim upon that? I cannot claim.
Can this be recorded?
Yes.
Okay.
No
just,
issue.
Just asking.
No issue. That will be the consequential flow. That will automatically will be there if I lose.
Because you take your own risk.
Yes.
You are constructing at your own risk.
Yes.
Okay.
That is.
Okay.
Otherwise, why I will suffer, Your Honor? 5 years, I won't be able to use my land. My right to property will be for 5 years. And that right cannot be compensated by money. How can I get the money from him that you have not allowed me to exercise my right? But he has the right, he will get the land because he is not in the possession of the land.
Just
So-
a minute. So just a minute. So this High Court's order is, it was passed in IA.
IA, Your Honor, this on without hearing on the first day. That's why today it's
The stay is stay
now
in the
now-
IA is without hearing.
Without hearing, It's-
Okay.
It's only the first date only. So today, this time only I am heard. So now since this is my lord, appeal against the order passed under 39.
Right.
So once appeal is disposed, this IA is not required to
Right,
consider.
right.
Because with IA, with appeal, IA will stand closed.
Now, any other condition or any other just order in the IA?
No. Till returnable
Only
date
till
status
returnable
quo.
date.
Till returnable date. That cannot be passed.
Just a minute. One, whether any justification given for. Okay, at the time of issuance notice.
Yeah. That was only till returnable debt. And my lord, that too, my lord, how this was obtained
It
with
was
the
a status quo.
status quo till returnable debt.
What is the status quo?
Status quo means I was undertaking construction.
So that is status quo.
That is status quo, but my understanding
It's
is
very
that
difficult to
because
explain the
they
status.
had put the case projected in a very different way.
It doesn't say also, not to.
Not to construct, but doesn't say.
Doesn't say. Status quo. What is the status quo? That is why I'm asking.
Under construction. At that point of time, I was undertaking construction.
Huh.
So meaning thereby, otherwise also I was allowed to do only.
So
So,
because-
I will not go to that because
no.
since my lord will be disposing the FA, this appeal, so these things will not be.
No, no, right. I just
Yes.
was confirming.
Now, once my lord decides the appeal on merit, so other things
Right.
is not required at all.
Okay.
Whether if my lord thinks that appeal has a valid, is merit, then my lord will set aside the order passed by the learned trial court, and my lord may grant any if as per their prayer if they have met. If not dismissed, then automatically that order will
Automatically will go.
stand.
Yes.
stand. Now, my lord, I will come to the facts. So this is my lord's query, right? Very proper query, my lord put. Now, situation. So all these aspects have been taken into consideration by the learned trial. This particular argument was placed there. Now, the argument was placed there. How it will be rebutted? Then there was a very fallacious and unreasonable argument to say how it will be. No, question of rebuttable anti-claim doesn't have. You have your, what is your prayer, Your Honor? You have prayed for first for a declaration of title, then for the recovery of the possession. That is their prayer. So once you win the case, so title will be declared and possession will be given to you. So if I have done anything, whatever, that will be on my own peril. And I'm so confident I have a good case so far here. So my lord, I will proceed with some facts. I will try to make precise.
Okay.
So my lord,
Fact probably has stated by the trial court also. No.
all this aspect has been taken into account.
In brief.
I look, we'll see.
In point.
Judgment of the trial court under challenge is so precise, dealt with every argument, every aspects have been taken into consideration, my lord. So I don't see it suffers from any perversity, arbitrary or illegality. My lord, before coming to the facts, first I'm just saying, trying to put on the, my lord, what is the scope of appeal under Order 43, which we are dealing with? The scope is, my lord, it is not something regular appeal, which we will deal on the merit of that.
Right.
Scope is very limited to the extent, my lord, will be seeing only whether the view taken by the learned trial court suffers from any perversity, arbitrariness, capricious. My lord will not be dealing with whether the view taken was wrong or right. Because, my lord, this is an appeal against the exercise of the discretion power by the learned trial court. So this is not like a regular appeal where my lord can go to the entire evidence and my lord can come to a different conclusion. The law says, my lord, in this kind of appeal, only because if I have a different view of point from the learned trial court, that doesn't allow me to interfere. Even if there may be a different possible, my lord will be on what is the, whether the basic principles followed by the learned trial court below or not, my lord? What is the perversity? That so limited scope is there, my lord, in this case. So, my lord, having said, my lord, the facts of the case in brief, I will put like this, my lord. My lord, the respondent, plaintiff, my lord, all together 3 sons and the plaintiff is the sisters. We are siblings now.
So same father, same mother.
Same mother, mother.
Mother also same.
Mother also.
Blood mother.
Blood mother.
Okay.
My lord. Then, my lord, what happened? In 1998, my father, like Kadu Takodia, he married a second wife in 1998. So, then, my lord, problem between my father and mother started. My lord, definitely whenever second marriage takes place, difficulty comes. So, at that point of time, we were with our mother. We supported our mother. Definitely, since our biological mother, we will be behind our mother. So, at that time, this mother, my mother, the plaintiff's mother also. She started taking the land of the father. Because my lord, that will definitely happen because she was worried because
right.
my children will be deprived,
Hmm.
second wife will take.
Hmm.
So she started, although she's from, she's general, not from the APST as Arunachal Pradesh. Of course, my lord, no judicial notice of the law that non-APST cannot acquire loan in the state of Arunachal Pradesh. I don't need to deal with that aspect, my lord. So still then, my mother, she surreptitiously obtained some LPC of this particular 12 hectares. Some others area also. At that point of time, since we were also young man, we supported our mother. Definitely we will support my lord, because what the mother was doing for us, my lord. That in 2003, mother LPC was issued in favor of the mother for 2.12 hectares of land. So, my lord, and immediately from the records I will show, father kept on writing letter to the mother and the deputy commissioner saying she is not entitled to this is my self-acquired land. My lord can understand this is the father's acquired land. Now they are trying to project, no, it's mother's land. How this is? I will show from their document also. They are also saying that this is a father's land. So when then father started making so many complaints to the deputy commissioner, to the matter also. Since you cannot obtain LPC of my self-acquired land. This is my land. All those things happen. Then issues both happen. My lord will remember one thing. In 2007, the plaintiff got married with one Mr. Samsung Bora. She shifted and started living at Pasigat since 2007.
She is elder.
Elder.
Okay.
But since 2007, she has been staying at Pasigat. So married, after marriage. Now we are left with mother. My lord, then, when there was a stiff opposition, objection from the father, then within the family, mother decided, mother called all the children, because mother was doing for the interest of the children. Then mother knew it that tomorrow there will be an objection since she cannot own the land in the state of Arunachal. She executed gift deed dated 12/4/2013. My lord. This is the admit, my lord. This gift deed in respect of 3 children, 3 sons. In respect of the suit land, my lord, 2.12, 3 sons. Responded, including 2 brothers. On the same day, my lord, what there, my lord, they to say that this is a fraudulent gift deed, it's so easy. But till date, this gift deed has not been put to challenge by anybody. And plaintiff has no authority to challenge this gift deed unless the mother challenges. Mother has not challenged it. This gift deed is still valid. It is, no one has overridden this gift deed, my lord. It is still valid. 2013 gift deed was issued. And my lord will see very interesting. On the same day, another gift deed by the same advocate, identified by the same advocate who is our registrar only presently. Another gift deed was executed in respect of nearby other land where the plaintiff has been given also the land. Plaintiff has been given also the land. In respect, 2 gift deeds were executed on this particular date, 12/4/2013, by this drafted by the same advocate, signatures and everything. But so far, first gift is concerned 2.12 that was gifted to 3 children, sons only. Then another plot of land by another gift deed on the same day, another plot of land to all the 4 children, including the plaintiff. Now, my lord, very interesting. Now,
4 children, including the
plaintiff,
plaintiff.
daughter also.
So the plot is different.
Plot is different.
Okay.
Now, my lord, we'll see very interesting how the plaintiff is now so has not disclosed about this fact in his pleading. Now, the plaintiff is only picking on the same day 2 gift deeds were executed, but now saying that 12/4 is a fraudulent document. Well, how? On the same day, 2 gift deeds were executed by the same advocate.
And the present gift deed also has a signature of the same advocate.
Same advocate, well, on the same date, everything is same. Then
that will come up during the evidence.
Yes, during evidence, but I am coming to that part.
Right.
Then thereafter, my lord, we'll see very interesting. Now, after gift, my lord, then my mother what started, this is the admitted position from their pleading also, I will show. mother started selling the land. The major portion of land
After that, after
after giving us gift deed,
after executing
Gift
the
deed.
deed. Okay.
she started selling the land. Otherwise, my lord
Without
yesterday,
knowledge.
yes, my lord yesterday put rightly question.
Hmm.
2.12 hectares given. Why I have taken only for 9,000?
Yes, yes, that is.
Otherwise, I would have taken. If my lord, I had any
Hmm.
such intention, bad intention, fraudulently, I could have gone for 2.12 hectares of land.
Hmm.
Why only 9,000 here?
Hmm.
Then mother started selling the land. This is an admitted position, my lord. To one taluk, Dirchi, Mekpe, Meme, Riba. She started selling all the land. Father also started complaining. We also wrote so many letters to the department. Don't entertain any gift deed since this has been gifted to us. Now, in that situation, since she is our mother, now how can I forcefully also contain her not to do like this? In the process, all the land she has sold.
Okay.
She has taken the money also by herself. Now we were helpless. Then, my lord, even once, I'll tell you, my lord, the mother, after selling the land, then within this 9,000 area also, my mother sold the land. This LPC area also. Then I had to interfere finally. Then there was a police case by the person Mikpi Taso, from whom my mother took the amount of rupees 26 lakhs rupees for selling the land, which is under the present dispute. Then undertaking was done by the mother before the Likhavali police station that I would return back the money. Mother was not in position to return back the money. Now, being a son, because I don't want to lose my land, only a small portion of land, now 9,000. Then from my bank account and my wife's bank account, my lord, I repaid even 26 lakhs rupees to the this Mikpi Taso in respect of this present suit levy. I had to repay, my lord. This is very unfortunate. Then, my lord,
whether these documents are available?
I have enclosed. I will come one.
No, not on record.
It is there on the record.
Okay.
I will come to that. I will just give the facts, then I will come to the document there. Then, my lord, then my brothers, two brothers, they write the letter to the DC. Since only left with 9,000, we don't have any objection for the issue of the LPC in respect of the left out area. Then left out is around 9,000. I will tell you, my lord. Then after that, LPC was issued in my favor on 13/6/2020 for an area of 9,559 square meters. But my lord, I will tell you, even from this LPC area, my mother has sold the land. Now I am presently left with only 7,539 square meters. Even I don't have 9,000 square.
So in the LPC, I haven't, of course, seen, I don't remember. So the northeast, southwest boundary showing whose lane. Is it in the middle of that 12 hectare?
My lord, sure. I will, let's see my LPC, my lord.
Because in the meantime, as you say that your mother has sold the rest of the lane.
My lord,
Okay.
my lord.
So earlier, what is it in the this 9,000?
My lord.
In the middle of the lane, the total lane of 12 hectare.
My lord, yes, my lord, come, let's come to page 96. My LPC, my lord. Now,
Yes.
my lord, page number
North Road.
96.
Okay.
North Road, South Knowledge, this Takap Mulum, my mother, to whom this my mother sold the land.
Okay.
Tagodoke, to whom my mother sold the land.
Okay.
Nothing is there.
Okay.
And my lord, very unfortunate, my lord, even I don't have this entire land with me.
Mhm.
I could have filed case against other person, but ultimately what will happen, man? My mother has to repay the money. It's a very unfortunate situation, my lord.
Okay.
Then, my lord, after obtaining, my lord, this LPC, my lord, I applied for bank loan. I applied for bank loan in the month of June 2022.
Applied for?
Bank loan from the SBI.
Okay, okay.
For housing.
Okay.
Well, my lord, I've been residing with, my lord, till that I don't have my separate house, my lord. with the that join that house I have been residing there.
With the
Now my children are grown up, my lord, and I'm married, my lord. So I just want to have one residential house just nearby only that property. Then, my lord, I applied for bank loan in the month of June 2022. Then, my lord, from July I started construction. July, my lord, kindly take note of the July 2020. Now my mother, she stays here. I am taking construction just nearby that place. Since July 2022, I have been taking construction. This fact is fully known to the plaintiff also. My lord, no action, nothing. They have been just allowing me to do. Now they filed the suit in the month of August 2023. My lord, we see up to 1 year of construction.
Okay.
After having erected all the pillar posts, when I was trying to put that chat first ground floor chat, at that point of time only, they filed the title suit. My lord, then first installment was of bank loan was issued to me on 14/12/2022. Then, my lord, since then I have been paying, my lord, interest. Now, my lord, because of the, my lord, this I have since order from this honorable, of course, no specific direction not to undertake construction. But still then, my lord, because status quo order is something, my lord, it can be interpreted here and there. So the client came to me and I said, my lord, better you don't do, since this is the order from the court. So we have to stop construction. Now, still I am incurring loss, my lord. My lord knows to construct a house, building, my lord, manpower, materials, so many things are involved. Everything was engaged. And since last 4 months, my lord, this has been kept in abeyance. Now, so low say I have incurred bamboo, chat was put already, my lord. So thereafter, my lord, now I will come to the fact, my lord, why title suit has been filed against me. There is a reason. So my lord may ask like, then why the sisters should do like this? Why the reason is that, my lord? My sister obtained one LPC on 1/5/2023 in respect of one WRC land for which another gift deed was issued. Other place, WRC.
There was also gifted by
Yes,
mother.
yes. On 1/5/2023, my sister obtained a LPC. So that WRC land is for all the 4 children. Now she surreptitiously in connivance with the mother. I don't know, my mother's, most probably my sister, she has managed her. So in connivance with her, she surreptitiously obtained a LPC in her favor on 1/5/2020. And my lord will find very interesting. In respect of that land, already LPC have already been issued in respect of all the children.
Okay, earlier.
Earlier. Then on coming to know, immediately we complained to the deputy commissioner, saying already LPC is there. This will be an overlapping case. Then after our complaint, my lord, then deputy commissioner cancelled her case. On, my lord, will see the date, on 17/7/2023, July 17/7/2023, she got offended. Then in the month of August, she files this title suit against me. But basically, otherwise, nothing is there in this case. Then thereafter, my lord, they managed to get at interim ex parte injunction order there also initially. But once we appear before the court, when all these facts were brought to the court, then court, learned trial court, said that no, this balance of convenience is in our favor. Their conduct is not appreciable. So for all this reason, declined to refuse the injunction prayer. Now, my lord, I will now come to the, my lord, if wants to peruse the document, I will come with, I can show the documents, my lord. Now, my lord, page number 70 to 71. Page number 70. My lord,
Yes.
my lord, this is the gift deed. First gift deed, 2013. In favor of 3 sons. in respect of the suit lane.
Okay, yes.
Now, unfortunately, I am left with only 7,000 area out of 2.12 hectares, my lord. Then, my lord, will see next page 72, my lord. My lord, on the same date, another gift deed was issued in respect of another land where, my lord, this Bobby Typodia, my lord, will page number 72 at the bottom, my lord, will find Dr. Bobby Typodia at the right side, page number 72. Yes, my lord.
Yes.
Yes, she is the plaintiff. So, to her also, by another gift deed, another plot of land was gifted to her also. My lord will see if she care, my lord, if she is this board gifted, my lord. It is on the same day. Advocate Lobsang Tenjing, Advocate Guwahati High Court. This now, my lord, very interesting. This plaintiff, my lord, dares to say that I have fraudulently obtained, but mother is not saying. What is the plaintiff has a business? Plaintiff can challenge, my lord, this gift deed, my lord. Process, my lord. Plaintiff cannot challenge this gift deed. If the mother says that this gift deed is fraudulent, then mother should have challenged this gift deed, my lord.
Yes.
How can plaintiff say, my lord, who is nothing to do with this transaction, my lord? He is the third person. And my lord will see this page number 72. It is the same gift date, signature same, advocacy is also same, on the same date. Now, plaintiff is not saying that this subsequent gift deed is wrong. Plaintiff is not saying that. Now, plaintiff is saying that another gift deed is fraudulently obtained, my lord. And my humble submission, my lord, she has no locus to challenge, my lord. Even if we say, my lord, even if she has a locus, my lord, but till today.
So 72 is also for all the children? No.
No. 72 is for children, my lord. The original is 70 and 71.
No, 70 and 71 is.
It's for three
the,
children.
For
Suit
the
land,
present
suit land.
suit land.
Yes.
And then this 72 is for
Another plot.
another gifted to
4 children.
Oh, here also 4 children.
My lord, first one is for 3 sons.
Oh, 3 sons.
And
Okay,
the-
here is for okay.
For daughter.
Yes,
also.
yes, oh, including daughter.
Daughter.
Okay, yes.
Why I am
Right,
trying
right.
to, my lord, bring this one.
Hmm.
If my lord, this daughter is saying that this
Then
earlier
this also will.
yes, this should also go. And she has not brought on record, my lord. Very interesting.
Okay.
She has hidden this fact from this court also, my lord.
Okay.
Then let's come to, my lord, undertaking, my lord, by the mother, page number 75. After, my lord, selling land, my lord, when I protested, my lord, why you are selling? My lord has seen, my lord, even my LPC area, my mother has sold, my lord. I'm not been left with the land, my lord. This is only the residential house. Now, my mother is writing before the police station. I, Srimati Akoni Tapodia, so and so, hereby affirm that as per resolution adopted at police station Likhavali in the matter of land case in between me and Srimati Mikpi Ribataso, I take this understanding that undertaking that I will repay an amount of rupees 26 lakhs 4,000 only by dated 22, failing which I will give the land as agreed by earlier. So, my lord, then because my mother was unable to repay back, then they would, my lord, take my land, my lord, LPC land. Then, my lord, what I had to do is, my lord, next page is the original undertaking, page number 76. Earlier, the type copy, my lord.
Okay.
My lord, then page number 77, document 5, my lord. Here, my lord, will see page number 78, my lord. Serial number, my lord, 1, 2, 3, 4, 5, my lord. 21st March check amount, my lord, transfer.
Serial number?
1, 2, 3, 4, 5, 6, my lord. 21st March.
Okay.
11 lakh 4,000, my lord.
Yes.
This is from my account, 11 lakhs, my lord.
Okay.
Then another again, my lord, I will show, my lord. Page number 80, my lord. Here also, my lord, 1, 2, 3, 4, 5, 6, serial number 6, my lord. 21st March, my lord. Another 15 lakhs, my lord. This is from my wife's account, my lord. Altogether, my lord, 26 lakhs 4,000 rupees.
Another, which one?
1, 2, 3, 4, 5, 6. Serial number 6, my lord. 15 lakhs rupees.
Serial number 6.
check withdrawal,
Page no, sorry, page number.
page number
18.
80, my lord.
Okay. Okay.
80. Another 15 lakhs, my lord.
Hmm.
Then altogether 26 lakhs, my lord.
Right.
I had to repay for this land also. Because my mother wanted to sell even the LPC land, my lord. This is very unfortunate, my lord, to say. Then, my lord will see, my father on 10/2/2000, page number 95, my lord. My father, before leaving for heavenly abode, my lord, on 10/2, my father writes to the deputy commissioner that kindly all those land in respect of kindly give, you allowed the land, give LPC to the plaintiff, my lord, my eldest son. I am the eldest.
This is which land? Different.
My lord? No, my lord, this also comes the same, my lord. Sawmill at Lipu, Likhavali. This is, my lord, this Likhavali area only, my lord.
No, not the suit land.
Suit land only, my lord, I think.
Suit land only.
My lord, suit land only.
This was written when? This 22.
22.
February.
Yes. Then, my lord, next page is, my lord, LPC.
No. Okay, this is before issuance of
LPC, before issuance
of 9,000.
Yes, my lord.
Okay.
Then, my lord, page number 96 is the LPC, my lord. Then, my lord, next page 97. 97 is the sketch.
96 is LPC. Okay, yes. this is
LPC, my lord.
Hmm.
My lord knows, my lord, this is LPC itself shows, my lord. Apart from their admission, that still I have a legal title over the land, my lord. I have a valid LPC, my lord. This is still not put under challenge, my lord. Even, my lord, not cancelled yet. Now, my lord, will see page number 97 is the sketch map, my lord. Then, my lord, page number 10, page number 98, my lord.
Is
98 is the, my lord, this bank loan, my lord, sanctioned to me on 14 December 2022, 35 lakh rupees, my lord. And, my lord, 98, 99, my lord, 99 is, my lord, showing, my lord, I have been paying the interest.
98 is bank loan and 99 is also?
I am showing, my lord, interest I have to pay for the loan, my lord.
Oh, it's page 99?
Yes, my lord.
Yes.
Then, my lord, applied for first installment was sanctioned. My lord, then kindly turn to page number 104.
Yes. What is this?
104, my lord. As I submitted, my lord, my sister, my lord, in collusion with my mother, my lord, she had obtained one LPC in respect of one WRC land, for which already LPCs had already been issued to all the brothers, man. Then we lodged the complaint. Not only me, my lord, including other brothers, my lord. We 3 brothers lodged the complaint.
Lodged complaint.
My lord, informing that, my lord, already LPC had been issued in our favor. So, in respect of the same plot of land, LPC cannot be issued. Pursuant thereto, my lord, page number 105. Deputy Commissioner, after inquiry, my lord, when Deputy Commissioner came to know about the fraud played by the plaintiff, Deputy Commissioner, by this order 17 July 2023, my lord, immediately cancel the LPC issued in favor of the plaintiff. Thereafter, only the present case siloged, my lord.
Okay.
Then, my lord, let's kindly turn to page number 110, my lord. This is the admitted position, my lord, when the suit was filed before the page number 110, my lord.
Yes.
My lord. When the suit was filed, my lord, already, my lord, this much of work was already completed. And my lord, they were waiting for me as if, my lord, and this was not something I was doing, my lord. I was doing, my lord, in secret. It is not something like that. It was openly I was undertaking construction. The question was, can it be allowed, my lord, at this stage, saying after, my lord, doing almost the major portion of the construction work, my lord. Now they filed the these things, my lord. Now, my lord, let's come to
This is their
my document, list of documents. In their appeal, they have enclosed.
Okay, in their appeal, they have
Yes,
included all
yes,
these documents.
yes. It's a list of,
according to you is in your favor.
no, my lord, because ultimately they have to come with all
Yes, yes,
documents.
yes.
But here, my lord, what the plaintiff did is, my lord, how plaintiff obtained that status quo order, my lord. My written statement was not enclosed with the appeal, my lord. But in law, it is also required, my lord. My written statement should have been enclosed, my lord. My lord knows while filing appeal, we have to put all the documents, either of the opposite party or this thing, my lord, because in appeal generally we don't file the affidavit in opposition, my lord, because this is appeal basically is on the basis of the record, my lord. So here my written statement was not enclosed. Therefore, my lord, in my reply to the IA, my lord, I have enclosed my written statement. I have brought on record my written statement because the document which they have not brought, I have brought in my reply.
Okay.
So, my lord, now, my lord, I will just, from their pleading, I will just show what are the admitted facts from their pleading only. Now, there itself, now they are taking two contradictory statements. First, my lord, page number, my lord, from their document, I will, so from para number 5, my lord, I will just read para 5. Page number my lord, page number 35. Now, what is the contradictory statement the plaintiff is making? The plaintiff is saying this is my mother's property. But it is in her document, my lord. The plaintiff has enclosed a document where the father is saying that this is my self-acquired land. That's why the landed trial court has remarked this particular point, that you are making two steps. One, you are saying this is my mother's land, not father's land, because our case is that this was the father's self-acquired land. Now, my lord, this is page number 35. This is the document, not my document. This is plaintiff's document. Now, here, they are using this document. Now, what she is saying? Father is saying, my lord, kindly from the bottom, 1, 2, 3, 4, 5, 6, 7th line from the bottom, my lord. I will read, this is my self-acquired land.
Yes.
This is my self-acquired land, not ancestral as they stated in their above mentioned petition. Now, father is saying, my lord, this is the father. And this is not my document, my lord. And my lord, I don't need to stress on this point. Otherwise, also, my lord knows that law says, my lord, my mother cannot acquire it. That is very clear. And it is their document itself saying this is a father's land. Why I am referring this one, my lord? My lord, if it is a father's acquired land, my lord, then my lord, plaintiff being a daughter, as per the Gallo customary law, she will not be entitled automatically, my lord. As on today, my lord, because we don't have this codified personal law, the customary law will prevail, my lord. So in that case, my case is that even if mother doesn't gift me, by virtue of the Gallo customary law, I am being the eldest son. Definitely, my lord, I will be entitled to inherit my father's property, my lord. Now, why they have enclosed this document, my lord? Just to show that father also objected against the issuance of LPC against them. But these are the subject to be proved, my lord. But what I am showing, this is their document, not my document. From their document, I am showing, my lord, their father is saying that this is self-acquired. Just for that point. Then, my lord, another very important point, my lord. Now,
Yes.
now they are using this document against me.
Mhm.
I am saying only, my lord, father is saying this is self-accord. Now they are saying father had also objected against me. What they are trying to, there's a, now my lord, another very interesting. My lord will see whether this gift, subsequent gift date, my lord, 2000, this my lord, 38/2022, my lord will kindly take note of the date. To me, it was gifted in 2013. Now, what they are saying that mother gifted them on 38/2022. This after 13, almost after 11 years. After 11 years, it's gifted. My lord will see very interesting here point. This gift deed, my lord, first part, this is unregistered. I will come to that point that from unregistered gift deed, no title will flow. So meaning thereby, she cannot file even the title suit. Tomorrow also his title suit will not be maintained because no right has been transferred. She cannot claim the title. Suppose assuming even this 38/2000 gift deed has been executed in her favor, since admittedly this is an unregistered gift deed, she cannot say that transfer of ownership has taken place as on today. Now another interesting thing. Now in this gift deed, now their area showing is that 2.12 hectares. Question, my lord, will see whether there is any area 2.12 hectares of land already sold. Even 9,000 area of land is not there. It's 7,000 area. They don't know the exact area also. That's why they say that by seeing the LPC, they also say that 9,000 they are fighting. But in fact, I don't have even 9,000 of it. Left with 7,000. Now, my lord will see how this gift deed will have any effect. Now, give it 2.12 hectares of land. Where is that land, my lord? Already murder is sold. And this gift deed, my lord, is not registered admittedly. So no title will come to
Whether the gift deed executed in your favor, it has been, was registered?
to my lord.
Yes.
No, for me also not registered. I admit. But my case is what, my lord? I have obtained a LPC.
Okay.
That is what the difference.
Right.
Yeah. So this is why I am saying that, because even if title, we say that mother has the title because possession is with me. Now, until if mother challenges me, that is a different case.
Right.
Mother can only challenge my possession. No one can. Because my lord, no. The law says the possession is the 9th point in law.
Right.
It is absolutely right against all the world except the real actual owner. What is the business plaintiff has? So for my possession of the land. Doesn't have to do. My lord will see page number, so for construction part is that para 8 of this schedule, page number 42. My lord. Page number 42. Why I am showing, my lord? This mother filed complaint on 22/8/2022, my lord.
Yes.
Kindly. On 22/8/2022, she is saying to the deputy commissioner that I have started construction work. August 2022. Meaning thereby, my lord, when this complaint was filed, I was already constructing, my lord. Then what? This complaint, my lord will see very interesting, my lord. 22/8/2022, now the plaintiff is saying that gift deed was issued in her favor. Now again on gifted, gifted, my lord, 19/5/2022, my lord saying. Now my lord will see on 22/8/2022. Now mother lodges complaint against me. Here, my lord, mother is not saying that the plaintiff is the owner of the land. Plaintiff has, if my lord, that land was gifted to her, why she did not lodge complaint against me? Why she did not file case against me? Why she waited for 1 year, my lord? My lord, now after giving, now if we go by the submission made by the plaintiff, this appeal, my lord, now saying that this land was gifted to them on 19/5/2022. Then why mother is saying, my lord, on on 22/8/2020 that she is the owner, my lord? Can she say she is the owner? My lord. Very interesting. If plaintiff is saying that it was gifted to me on this 19/5/2022, it was her duty to pursue the matter, my lord. To file the case against me, to lodge the complaint against me. She has done nothing. But only in the year of 2023, August, she files the case. My lord. This is for this point, my lord, I am showing this one. Now, my lord, having said these are the, my lord, facts, my lord. Now, my lord, will see my reply, my lord, page number 49, my lord. My reply, kindly turn to page number
Reply to?
20, reply, my lord. Page number
Okay.
48, my lord, page number,
Starts from 48.
page number 49. At the time, my lord, when the status quo order was issued, my lord, I was undertaking this.
Okay, it's before the civil judge.
Yes, 49 and 50, my lord. This, my lord, I was doing, my lord. Because once, because initially, my lord, ex parte order was granted in favor of them. There also I could not do. Then once it was refused, I was undertaking work, my lord. So all of a sudden, my lord, I had to, my lord, stop the construction. Now, my lord, having said this, my lord, now submissions, my lord, point of law, grounds, my lord, why this appeal is liable to be dismissed. First ground, my lord. My lord, first ground, to file a title suit, my lord. Of course, my lord, we are not here saying, my lord, that it has to be proved. No, my lord, because proof is yet to be done. But, my lord, prima facie, my lord, plaintiff has to show that he has a title, my lord, whether required or not. My lord, if I am filing a title suit, do I not require to the court to prima facie to show that how I have a title over the land? Here is the case, my lord. Possession is with me, no dispute. Now, plaintiff is saying, by virtue of gift deed, she acquired the ownership. Now, my point of that, ownership cannot be transferred without there being a valid registered gift deed. First point. Second point, my lord. Before that, my lord, already in 2013, there is already one gift deed, my lord, that is not yet challenged by the mother or not by anybody, still valid, my lord. How can the subsequent gift deed can override the, my lord, first gift deed, my lord? Can it be done, my lord? If I execute gift deed today, then after 10 years, another person can say, my lord, no, I have a gift deed. Your 10 years earlier gift deed is invalid. Can it be? First, the mother has to file the case before the court and to prove that earlier gift deed was fraudulent or forged. Then only, my lord, these subsequent things will come up. But here is the case, my lord. This is subsequent in nature after 11 years of the first gift deed. Now, my lord, second part, my lord. Admitted position, my lord, construction since 2022, almost major portion of the groundwork completed, my lord. For whole 1 year, despite they were fully aware of the construction activities, they did not file any case. It was only in the month of August 2023 when, on the basis of my complaint, their LPC was cancelled. That's why, to take the revenge, this case has been filed by the sister. Now, my lord, what are the three basic principles for granting the injunction order? My lord will see only while hearing the appeal whether the learned trial court below has taken into consideration these three principles or not. My lord, learned trial court, from the record I can show, my lord, she has fully discussed about these three principles. My lord, principle of prima facie. Now, in this is the case, even doesn't have prima facie case, my lord. Forget about other balance of convenience and irreparable loss and injury. Even where is the case of prima facie case? Title cannot be transferred. How she can claim herself to be the owner of the land? Whereas LPC is admittedly with me, possession is with me. Since last 1 year, I've been taking under construction. Then first point, no prima facie case even. Then second, balance of convenience. My lord, as I have said, my lord, to get the injunction, my lord, a person has to show that he is in the possession of that. That is the requirement of other order 39, my lord. I will come to that point. You being without having the possession, all of a sudden you will jump from the sky and all of a sudden you will say, stop, you cannot do it, my lord. This cannot be accepted. This will be a very dangerous proposition. Anyone can file title suit against anybody, my lord. You can say this document is forgery, this document is duplicate. Well, saying is so easy to say, but how you will prove it? You have to prove it first. Now, my lord, who will suffer irreparable loss in injury? Is it the plaintiff or me, my lord? As my lord's query, earlier query was the right query, my lord. And my answer, my lord, is, my lord, I reiterate that, my lord, she will not suffer anything. She will get back. Maybe, my lord, with my structure she may get, because I will not, I will not damage my structure, my lord. Why should I? My sister, let her take.
Okay.
My lord, then, my lord, condition of order 39, rule 1, my lord. I will just read out. I will just summarize, my lord. Now I won't take much time. Order 39, rule 1, my lord. What is the condition is required, my lord? Order 39, rule 1. My lord, rule 1, then C will be applicable, my lord. Rule 1C. My lord, this is the says, order 39, rule 1 says, cases in which temporary injunction may be granted. My lord has got.
Yes, just a minute. Yes.
Temporary-
C.
Yes, my lord.
Yeah.
C.
Mm.
My lord, these two condition is not applicable. A and B is not applicable in the present case.
Right. Mm.
Third, my lord, it can be allowed only when the defendant threatened to disposes the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit, my lord. Now, here is the case, the plaintiff is not in the possession of the land, my lord.
Mm.
My lord, had it been in another case, the plaintiff is in possession, I forcefully taken, or I am trying to dispose him from there, then, my lord, injunction is approved.
Mm.
So this condition is not fulfilled in the case, man. Possession is with me 1 year. I've been taking construction. How the injunction, man? That's why, my lord, this condition is not fulfilled. Because three conditions are there. A and B is not applicable. This C condition even not applicable. That is one my submission, my lord. Then, my lord, give deed is this thing. Then, my lord, I will come to, my lord, kindly turn to page number, this evidence of section 110.
Evidence.
My lord knows, section 110, it talks about the burden of proof as to ownership. My lord, let's assume, for the sake of argument, that there is no LPC even with me. Let's assume for the sake of, even no gift deed was executed in my favor by mother. Even, my lord, for the sake of argument, assuming I am in the possession of the land. Mother has not gifted me, there is no LPC, even, my lord. Even then, my lord, law says, my lord, I will be protected. What the law says, my lord? When the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirmed that he is not the owner. Now, a presumption will be there, my lord. Forget about all these details, my lord. The moment I have the possession, the presumption comes, my lord, I am the owner. Now, that presumption has to be discharged by the plaintiff during the trial, my lord. And here is the case, it is not only possession. I have constructed a structure even. Now, my plaintiff wants, my lord, before going for trial, we should presume that she is the owner and I should not be allowed to construct. What is this argument? This very dangerous proposition has been sought to be, was argued, my lord. Possession is respected highly in law. My right is absolute against anybody, my lord. If tomorrow mothers comes and file case against me, and if she proves, then only she will get. Otherwise, not. Then, my lord, section 56 and 57 of the Evidence Act itself. Facts of which the court must take judicial notice. Why I am referring this section, my lord? What are the things my lord can take judicial notice is the law, my lord, that non-APST cannot own the land in the state of Himachal. This is a law, my lord. My lord can take judicial notice of this fact. This is the law. My lord can take judicial notice of the custom of the Galo tribe, how the properties are bequeathed, how it is succeeded, my lord. My lord knows, my lord. Everybody knows, my lord, these are the sons are only entitled to inherit the land, my lord. Of course, I personally, I believe that girls should also get equally. That's my personal opinion, but customary law is something different. Unless that such custom has not been so far declared illegal by any court, so still that custom isn't valid. No one has put to challenge to that customary as on today, man. So we are not, because here is not the point. We are not with the issue whether such custom is valid or not valid, man. We are here in the issue which is as it is, that daughter is not entitled to inherit the especially immovable property of the father, my lord. Now, having said that, my lord,
so that would be only if the owner or if there is no any gift deed. If there is a gift deed, if the owner can, supposing a father, by executing a gift deed, can also give it to the daughter also.
daughter can be. There is no issue.
But then, of course, here is a case, maybe, of course, something different.
Yes.
From that, because so far.
So far, daughter is concerned, APST can be given. But, my lord, statutory law says, my lord, non-APST cannot acquire.
Right.
That is the law. I am not on the wisdom of that law, but law, that is the law. Now, my lord, now another point, my lord. Question is, my lord, we kindly take note of what is the locus of the plaintiff to challenge the deed executed by mother in my court. Can anybody XYZ come and challenge any document? How she can challenge the deed? I don't understand. Third party cannot challenge. This is the transaction between mother and son, my lord. Now, let's assume, even this gift deed was fraudulent, assuming. Who is the right person to challenge, my lord? It is the mother. Mother has not filed so far any case. Now, daughter, my lord, and mother is not the party, my lord. My lord, kindly note, necessary party in the case, mother has not been made the party even in the case. My lord, plaintiff is saying that she has got the land from mother, but mother has not been made the party even in the case. At least she should have been in the case, my lord. This is very interesting, my lord. Now, my lord, LPC issued to the defendant is still valid, my lord. No one has, it is not yet cancelled, my lord. It reaffirms my possession. Because my lord knows that private land, my lord, LPC is issued. Yesterday, my friend was arguing, my lord, I think he is not well versed with the law of Arunachal, my lord, that government land is different and private land is different. So for government land is concerned, allotment is given. So he was making yesterday submission that when LPC issued, government has sanctioned him, allowed the mother. This is a wrong submission. Government can give the land of government land. How can government give the land of private land?
That is allotment.
Allotment land, government can give it to anybody also.
LPC
can. Government has to acquire the due process of, this is a constitutional and human rights. So that submission was preposterous and not legally sustainable, my lord. Now, another ground, my lord. I even paid money for this particular land, my lord. Now, thereafter, my lord, this Bengal Eastern Frontier mother cannot have the land, my lord. Then, my lord, very interesting. Cannot have the land. Therefore, my lord, when I made the complaint, LPC has been cancelled. Mother's LPC has been, of course, that is the subject of the writ petition. I have put my appearance, and likely, my lord, that that decision will go in favor of the administration only, because there is a law. Unless that law is not put into challenge, my lord, how we can? First, that law has to be first declared whether this is a valid law or invalid law. But until, because they have not put
Who filed with petition?
Plaintiff
Against?
against
The cancellation?
mother has filed
Okay, against the cancellation.
cancellation, but has not put challenge to the act.
Okay.
Act is not under.
Then we will
She
take
said
it
that
up.
LPG has been cancelled. I don't know how they will go it, because law is very clear. That is there. Now, my lord, will see in the entire pleading of the India title suit, not a single whisper of how prima facie in case is there, how the balance of convenience lies in favor, how this irreparable loss and damage, because law says that in the pleading you have to specifically state how this three principle will be fulfilled. My lord is completely silent, my lord. Now, my lord, another factor. My lord, yesterday put right question. Since you are challenging this give deed, are the other brothers are party or not? They have not included other brothers. Now they are telling you 2.12 2013. Why others brothers have not been made party also? That was also exactly, my lord, yesterday put the query. Then, my lord will find another very interesting. In the present appeal, there is no prayer. No prayer.
Okay.
Nothing is there.
No prayer.
No prayer in the present appeal. Just right. And how this court will give the relief, I don't understand. My lord, kindly, after page number 12 till it's the ground of appeal, then direct 13 certificate. Even no prayer is there. Even here is no statement as to how. Page number 12, my lord.
Yes.
This is the appeal. What to type this? Appeal.
Okay.
From 12 straightly 13 certificate. If I am wrong, if I am not wrong. Because only, my lord, cost is not enough. After that, what injunction you are seeking, my lord?
Right. Okay.
Well, if you don't seek the
relief to be given.
My lord, even, my lord, if set aside, if my lord doesn't give any injunction, it will remain as it is only. Because by learned trial court has not granted injunction. So meaning thereby that is as it is only. Okay. There is no prayer, and my lord knows that principle of lay. Without prayer, that too in the civil matter, my lord. Court cannot go beyond the pleadings, my lord. Cannot grant the prayer which has not been sought, my lord. Even, my lord. They should have sought, my lord, for any injunction from this honorable court, my lord, because this is the appeal. Nothing is there. That is one of the major defect in the present case also, my lord. Then, my lord, I will come to my lord, section 56 of the Limitation Act, my lord, says, my lord, that if any document, if you are alleging that this particular document is not valid, it has to be challenged within 3 years.
Yes.
Here is the case, my lord, 2013. But I'm just referring, my lord, because otherwise plaintiff has no locus. That will be my first argument, my lord.
So now,
now, my lord, I will with that, my lord. Now it's almost after 11 years.
So now even if they challenge also, it will be barred by limitation.
Barred by limitation.
Okay.
Even that part also title should, my lord, prima facie not maintainable, my lord. My lord, Section 7 of the Bengal Frontier this Regulation Act says, my lord, that non-APST cannot acquire the land in the state. It's very clear, my lord. My lord, whether I need to read out the provision or my lord.
Let us just read it once.
My lord.
For
Section 7.
what's there? Yeah, let us.
One. Section 7. May I read, my lord?
Yes, ma'am.
Page
Yes.
number, my lord, 10.
Page number
10.
Yes. Yes.
It shall not be lawful for any person not being a native of
Just a minute. Page number 8.
10, my lord. My lord, now I think, my lords, I think volume maybe, I am having the old version of the book, maybe page may not be same.
Okay, it's
Section 7 of the Bengal Frontier.
just a minute. No, this is
Bengal Frontier. Bengal Eastern Frontier Regulation 1873, my lord.
Yes, it's
My lord.
page 3.
Page, section 7, my lord.
Yes.
It shall not be lawful for any person not being a native of the district comprised in the preamble of this regulation to acquire any interest in land or the product of land beyond the said inner line without the sanction of the state government or such officer as the so and so. So meaning thereby, yesterday my friend was making wrong reference of that LPC issued is sanctioned, not issue LPC is different thing. That was wrongly issued. That's why on detection, the deputy commissioner has immediately catched. Wrongly issued, man. Now sanction is completely different. Sanction should be from the minister level, from the government, man. From the cabinet, my lord.
Sanction has to be, of course.
From the
At
cabinet,
government level,
yes, from the cabinet, my lord, approval has to be there that even though it is outside, non-native of the state of Arunachal Pradesh, he can be allowed that way. But again, one rider is there, my lord. It can be only with respect to the government. How the private land, unless government acquire? What the government has right to give my land to another group? Cannot government. Now, my lord, Arunachal Pradesh Land Settlement and Record Rules 2012, Rule 123 clearly stipulates, my lord. 123 rules. रूल्स उसमें नहीं होगा इसको देखा कोर्ट में नहीं हो गया कुछ होना चाहिए लैंड रेकॉर्ड रूल्स हाँ Hello, Rule 123.
Rule
1, 2, 3, my lord. Eligibility for allotment of land.
Page
Rule 1, 2, 3.
1, 2, 3.
My lord. Eligibility for allotment of land. the following shall be eligible for allotment of land under section 12. A person,
Just a minute, this is. Rule 1, 2, 3.
1, 2, 3. Eligibility for land allotment.
Government of Arunachal Department, which one?
Arunachal Pradesh, my lord, land settlement
and-
record rules 2012.
Rules, just a minute. This is it. Rules is inside.
My lord, this is the copy I have with me.
Page, same, then page 20.
I think this is, that
Same, I
is
think.
different, it seems, my lord.
Different.
123, my lord, is reads out, my lord.
Content is also not, there is no content. No. Okay. Just a minute, huh? Yes,
My lord.
yes.
Came out, my lord. Now, my lord, yesterday, my learned friend for the appellant made the argument that the transfer of because give deed without registration is illegal. That is a completely erroneous submission, contrary to the law, my lord. My lord knows that transfer of property is very much in operation in the state of Arunachal. We cannot do any transaction of the property without following the Transfer of Property and the Registration Act, my lord. That's why nowadays, my lord knows that give deed, sell deed, all are to be registered as per it. My lord, this Transfer of Property Act and Registration Act that has been adopted by the state of Arunachal Pradesh by virtue of the Central Laws Extension to Arunachal Pradesh Act 2007. And since 2007, this is the notification, gazette notification. This is the notification by which, my lord, Transfer of Property Act, Registration, so many, CPC also, my lord, since then, my lord,
Yes.
fully made applicable. That's why that argument is not sustainable. Referring to the Land Act doesn't say that registration is not required, my lord. That is a completely in different context. My learned friend has tried to put, but that submission cannot be accepted because that will lay a, my lord, wrong precedent. Wrong law will be laid down if we accept the submission, my lord. Then, my lord, let's see the order of the, my lord, learned trial court, my lord. I will not read entire order, my lord. I will just, my lord, let's see page number, it starts from page number 113. It's a very comprehensive and exhaustive order, my lord. Every argument, every aspect have been minutely discussed and taken into consideration. And starts from page number 113 onwards.
Yes.
I won't read, my lord. All these aspects have been dealt, my lord. Then my lord may I take that even, my lord will see these aspects. First, my lord, the learned trial court has taken into consideration each law has been discussed, my lord. First case, my lord, case number 113, prima facie case.
Yes, three principles.
First discuss, my lord. Thereafter, my lord will see balance of convenience, my lord, page number 118.
Yes.
This particular aspect has been discussed, my lord, because since I have been undertaking construction, how at the middle of the time, my lord, abruptly someone can be stopped, my lord. When admittedly position is my favor, they said that balance is in favor of the defendant. This has been thoroughly discussed, my lord. Then, my lord, page number 121, my lord. Irreparable loss in, my lord, kindly, I will read paragraph, this paragraph 32, my lord. I will just read paragraph 32 only, my lord.
Yes.
And paragraph 34. I won't read much, my lord. The counsel for the head raised concern that if the construction or then in the event the suit is decreed in favor of the paid, turning back the clock to the present state would be almost impossible. However, this court is of the considered opinion that plaintiff has made no mention how she will suffer irreparable loss or injury if in the injunction is not granted. On the other hand, defendant herein being in possession of the land has carried out the construction a year back, and the plaintiff has also not given any reason for her inability to approach this court immediately after the property was gifted to her. My lord, this aspect has been discussed here, my lord, that not a single statement has been made how suffer injury, my lord. Now thereafter, my lord, 34, my lord.
Yes.
Thus, in the light of the conduct of the plaintiff, the loss and damage likely to be caused to the defendant is greater than that would be caused to the plaintiff. My lord, this is a very right observation, my lord. My lord, conduct, my lord, I will show one judgment. In such cases, the apex court says that apart from these three principles, my lord, fourth principle, conduct of the parties is very important. Had the plaintiff promptly approached the court immediately, when I was not allowed to take, I was in the initial stage of the construction, of course, matter would have been even, but even then doesn't have good case. So far, this ownership has not been transferred. So all this aspect has been thoroughly discussed in this case. My lord, repeatedly reading also, I don't see, my lord, this order suffers from any perversity. My lord, possible view may be different, but on that ground, we cannot interfere. Only, my lord, this should be, law has not been fully discussed, or the factors have not been taken into consideration. But this is not this case, my lord. All these principles have been taken in. Now, my lord, I will conclude by citing some judgments only, my lord. Immediately, my lord. Time. 1990 supplementary SCC 27. This judgment was relied by the learned friend also, but he did not read out the main principle of law set down in this particular judgment, my lord. Para 9, my lord. Of Para 9, page 7 to 7. Huh? Para 9, my lord.
This judgment was present yesterday.
Yesterday present, but he has, my lord, skipped the important principle of law laid down.
The paragraph which was advantage to him.
My lord, this judgment was, my lord, against the order, my lord, wherein High Court gave the injunction order. When the trial court, my lord, did not give the injunction order, then the High Court in appeal granted injunction order. Then the Supreme Court said that High Court has done wrong because this is not the appeal, regular appeal. You cannot go for a alternative opinion. Only court has to see with the limited scope whether there is perversity or not, my lord. That is the judgment, my lord. I'll just read out Para 9, my lord.
Para 9.
Yeah. Para 9, my lord. Para 9 and 9, 13 and 14. I will just read Para 9. Usually, the prayer for grant of an injunction is at a stage when the existence of the legal right asserted by the plaintiff and its alleged violation are both contested and uncertain and remain uncertain till they are established at the trial on evidence. The court at this stage acts on certain well-settled principle of administration of this form of interlocutory remedy, which is both temporary and discretionary. The object of the interlocutory objection is, it is stated there, is to protect the plaintiff against injury by violation of his right for which he could not adequately be compensated in damage recoverable in the action if the uncertainty were resolved in his favor at the trial. The need for such protection must be weighed against the corresponding need of the defendant to be protected against injury resulting from his having been prevented from exercising his own legal rights for which he could not be adequately compensated. The court must weigh one need against another and determine where the balance of convenience lies. The interlocutory remedy is intended to preserve in status quo the rights of party which may appear on a prima facie case. The court also, in restraining a defendant from exercising what he considers his legal right, but what the plaintiff would like to be prevented, put into the scale as a relevant consideration. Whether the defendant has yet to commence his enterprise, my lord, now very important. Now this consideration, whether the defendant has yet to commence his enterprise or whether he has already been doing so, in which latter consideration somewhat different from that applies to a case where the defendant is yet to commence his enterprise are attracted. Here is the case, my lord. This injunction granted by the High Court was set aside by the apex court, said that in this case, this defendant was already undertaking the business, my lord. Therefore, my lord, cannot be. Now, my lord, let's come to para 13, my lord. This is para 13 and 14, my lord. This is important. On a consideration of the matter, we are afraid the appellate bench fell into error on two important propositions. The first is a misdirection in regard to the very scope and nature of the appeals before it, and the limitation on the powers of the appellate court to substitute its own discretion in an appeal preferred against a discretionary order. The second pertains to the infirmities in the ratiocination as to the quality of an talks alleged user of the trademark on which the passing of action is founded. We shall deal with this two separately. Para 14. The appeals before the division bench were against the exercise of discretion by the single bench. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of first instance and substitutes its own discretion, except where the discretion has been shown to have been exercised arbitrarily, capriciously, or perversely, or where the court had ignored the settled principle of law regulating grant or refusal of interlocutory injunction. An appeal against exercise of discretion is said to be an appeal on principle. Appellate court will not reassess the material and seek to reach a conclusion different from the one reached by the court below, if the one reached by that court was reasonably possible on the material. The appellate court would normally not be justified in interfering with the exercise of discretion under appeal solely on the ground that if it had considered the matter at the trial stage, it would have come to a different conclusion. If the discretion has been exercised by the trial court reasonably and in a judicial manner, the fact that the appellate court would have taken a different view may not justify interference with the trial court exercise of discretion. And while saying that, it's a very limited scope. So for appeal in the present case, because this is not appeal on, my lord, this is appeal on principle. This is not like regular appeal on merit, my lord. My lord, if the learned trial court on the basis of material has come to a certain view, my lord, and which is supported by the law, my lord, then, my lord, the appellate court would not be in, my lord, within the scope of so far this appeal is concerned to reassess the entire material, my lord. And even if another opinion is possible, that itself cannot be reason to interfere. But this is what the, my lord, this judgment is saying, my lord. This is this particular judgment, my lord. Now, my lord, kindly 2013 9 SCC. I'll just read simple paragraph 221, case number 221.
So books cannot be carried. If you have the then the Xerox copy may be presented.
Xerox copy, my lord, I have with me, my lord. This yesterday, my lord, this judgment was referred. Or otherwise, this can be kept. I can have, my lord, different judgment, no problem. There. Page number 2013 9 SCC 221, my lord. My lord, here I will just mention the paragraph because here also, my lord, same thing discussed in this particular judgment, my lord, has been referred. Para 20, 21 and 22. This judgment of Wonder Limited has been discussed and reaffirmed, my lord. In this judgment.
Same one.
Same, my lord, discussed, saying, my lord, how this should be done, my lord. Then thereafter, 1987, I will give you. 1987 supply SCC 166, my lord. Yes, ma'am. Okay. My lord, I have marked the only simple page, last paragraph highlighted, my lord. It says, my lord, injunction cannot be given in favor of a person who is not the possession of the land. How injunction can be given against the person who is not in the possession of the land? So this is for that one judgment, my lord. Now, my lord, another 2008. 2008 11 SCC 1.
Yes.
My lord. This judgment completely comes, it's almost, my lord, identical in this particular case. Here also, my lord, construction was already there, my lord. Then, my lord, learned trial court did not allow injunction. Then injunction was given. The matter went to the Supreme Court. Then Supreme Court said, no, since construction was already there, you are not doing anything. Your conduct, because of your conduct, you are not entitled for that one, and no injunction can be given in such case, my lord. May I read para 21? What's the para 21 onwards? I will just read much. Para 21. While considering an application for grant of, my lord.
Para 21 is page.
Para 21, page 8, my lord.
Okay.
I'll just read. Para 21, my lord. While considering an application for grant of injunction, the court will not only take into consideration the basic elements in relation thereto, existence of prima facie case, balance of convenience and irreparable injury, it must also take into consideration the conduct of the parties. Why I am referring this, my lord? Apart from these three, my lord, conduct of the parties. Right. And here is the conduct my lord has seen after 1 year, CS approach for this part of para 22. Grant of injunction is an equitable relief. A person who had kept quiet for a long time and allowed another to deal with properties exclusively ordinarily would not be entitled to an order of injunction. The court will not interfere only because the property is a very valuable one. We are not, however, oblivious of the fact that grant or refusal of injunction has serious consequences depending upon the nature thereof. The courts dealing with such matter must make all individuals to protect the interests of the parties. For the said purpose, application of mine on the part of the court is imperative consensus. Thereafter, my lord, para 26, my lord. Now, this paragraph is completely, my lord, relevant to my case. Para 26, my lord.
Yes.
My lord. Rightly or wrongly, construction have come up. They cannot be directed to be demolished, at least at this stage. Respondent number 7 is said to have spent 3 crores of rupees. If that be so, in our opinion, it would not be proper to stop further construction. Thereafter, there are 27 months. We therefore are of the opinion that interest of justice would be subserved if, while allowing the respondents to carry out construction of the building, the same is made subject to the ultimate decision of the suit. The trial court is requested to hear out and dispose of the suit as early as possible. If any third party interested is created upon completion of the construction, the deed in question shall clearly stipulate that the matter is sub judice and all sales shall be subject to the ultimate decision of the suit. All parties must cooperate, so and so and so. So here what is saying, my lord, that since construction has already done, my lord, that's why injunction cannot be done, my lord, and it can be always at the letter end, it can be always subject to the outcome of the case, my lord. But that is always there, my lord, because if he wins, she wins, she will get, my lord. Then, my lord, even if the property, if I sell, my lord, during this period, that will be the doctrine of lis pendens will be attracted, my lord. During the pendency of the case, if any transaction plays, it cannot be, my lord. So that apprehension is misplaced, my lord. Now, my lord, this gift of immovable property, my lord, 1996. sorry, my lord, my lord, this judgment I have highlighted that without registration, no right can be transferred. That is clear, my lord. Just put it. I have highlighted below, my lord. Then, my lord, one more judgment. Yeah. 22. My lord, then another judgment, last judgment, my lord. This is regarding, my lord, that if no prayer is made in the pleading, relief cannot be granted, my lord. To support this judgment, my lord. This is para 16, 17, and 18 and 19.
This is without registration.
My lord.
Okay, no immovable property
Can be transferred.
Okay.
So it is no title can be transferred. She cannot raise the issue, mother. At the most, mother can raise, if at all, if mother wants. She cannot. Plaintiff can. How the plaintiff can challenge my possession? My lord, then subsequent judgment, para 16, 17,
para
16, 17, 18, and 19, my lord. My lord, just to say, my lord, without prayer, my lord, no relief can be granted by the court. And there is no prayer in the pleadings.
Okay.
What is there? And I've in the appeal petition, I have forgotten, I think, to improve. If I am not wrong, if I have not been served different copy, my lord, page number 12, after that immediately 13 is there. Now they may say in the title suit, because in their appeal.
Okay, okay.
So in the title suit is different, my lord. So
Okay.
here is the case, my lord, they are inheriting, they are raising under appeal 43, my lord. So appeals, prayer should be there in the appeal petition also, my lord. Now what they are saying is that, my lord, that it is in the, these things, title suit, mostly. Otherwise, not issue, even if it prayer is there, I don't know. They may not have given me the right copy also, I don't know, my lord, what they have done.
No, there is no prayer. Here also.
Prayer there, my lord? Okay, I have not been given, sir.
No, I haven't seen.
Page number, my lord? Page number?
No, I haven't seen the prayer.
Yes, yes, yes.
Just a minute. So the prayer is in the, I think they are, yes, in the title suit.
Title suit is different.
There is a prayer.
I am in the appeal petition. With this, my lord.
Yes, yesterday the prayer read, I think this title suit.
Yes, my lord. Otherwise, also, my lord, I will assume let the prayer be there, but with the, doesn't have any case, my lord.
Okay.
So, my lord, with that, I will conclude my argument. My lord. My conclusion is, my lord, that admittedly possession is with me. 1 year more than, my lord, I have been doing. LPG is my favor. My gift did not under challenge, my lord.
Yes.
Her gift deed is, my lord, not proper. Tomorrow, my lord, she will not suffer. She recover it along with my, I think, building also she will get. My lord.
Double benefit.
She will be in the advantage position. Well, with this, my lord, I conclude.
Anything?
My lord, there are many things which my brother has.
I think we have covered all yesterday.
No, my lord. Now, he has made some statement which is misleading, misguiding. So I'll point out that because I have that right.
How long it will take?
In 15-20 minutes.
15-20 minutes. Do we have? No, I think
Because
yesterday I think we have exhausted.
why? Because my lord, they don't have the case, and they know they will lose the case because of they are pressing hard to finish this construction. They know the fate of the cases, and how I'll explain.
No, the submission was on record, I think. You have seen the record.
Yes, I have seen the record. I have seen.
And
I
beyond
have
the
gone
record,
through
I
the
think,
entire
beyond the
case.
record, what he has submitted, just point out that.
He has submitted that since the LPC gift deed of mother is not registered, and the gift deed of the
Was it registered?
is not registered.
Okay.
Admittedly, it is not registered, and their gift deed is also not.
No,
registered.
that admittedly,
And then
admitted.
LPC, which they had obtained, it was obtained on the basis of this unregistered gift deed. So when things are proved on the illegal things, how, whether that will be correct for you. Because they have on the base, on the stand of the LPC, they are saying that this shoot lane, they are in position since 2022. Forcefully they have entered. And now they are constructing, and now they are saying we have the LPC. And might not see the LPC. In the LPC, it is clearly stated that this LPC issued on the basis of the gift deed of the mother. And mother gift deed is the unregistered. And the daughter gift deed also is unregistered. But subsequently, the daughter has registered his gift deed. And that thing he has not informed this court. And there are so many things. If might not give me 1 hour, then I will disprove. Because this is not a fact finding committee. What this court, the issue before this honorable court, please give me some time.
Unlike your colleague, I don't interfere.
He's one of my favorite singers. But today he is misleading.
But one thing, my lord, this word misleading, they use so easily. I always keep refrain. Rather you
No, that is
better
why I'm-
misleading word, I think,
I will
because
satisfy the court
so
whether it
easy.
is misleading or not, because
This
I
is-
don't have
this is-
any
this is-
specific word for misleading.
No,
When things are misleading.
I never do, I never
I
intend.
think the time, I think we don't have enough time.
And my lord,
So if you want to take 1 hour, I think we may
my lord,
have
just
to.
give me
extend
10
to
minutes, then this argument can be postponed for some others day. Because in 10 minutes, it cannot be completed.
What more argument you want to put?
Because.
No, what I'm saying,
yes.
is you have seen that he was submitting on the basis of the record. He has pointed out the papers also. So what is the submission which he had made with, off the record? You just pointed out that.
I know.
So one thing you have pointed out that your gift deed is registered. Has been- was-
It is unregistered.
No, yours is registered, you said.
Yes, mine is registered, and this is the.
I think you have annexed the document.
No.
No,
So this is for the first time you are submitting.
yes. But in the trial court, we have submitted.
Hmm.
In the trial court by way of amendment, we have submitted.
So then, what we'll do is in the meantime, I'll keep the judgment reserved to submit your written argument.
My lord,
Written in the meantime, I'm giving you 1 day, 24 hours. You are asking for 1 hour. I'm giving you, okay, you submit by Monday.
my lord, then 5 minutes I submit and I will submit the written argument. That is 5 minutes.
Okay.
No, my lord, we kindly see the order of the High Court order. The High Court not only passed this, simply mechanically passed this order. The High Court.
Which High Court?
Bench Guwahati has put some remark after hearing the exhaustive submission, after going through the entire petition plaint and the document. Thereafter, this honorable court has applied his judicial mind. He has put that opinion, because during it appears they are constructing, and during the pendency of the suit, the subject matter of the suit has to be preserved, and this is the settled law. And the delay in filing the suit cannot be ground for not allowing the temporary injunction. That is, we have the n number of cases. And also, my lord, how this the Learned Court order is perverse and capricious, because
Whose order?
in the Learned Court, civil judge, senior division.
Okay. But then yesterday you have pointed to everything. And I've
More
given
than
the-
2 hours they took yesterday.
So that is why I'm saying, if it is going to take longer time, and if you are going to repeat it, it is always better that you file a written argument, written submission, okay? That will be better. It will be on record also. So you also, if you want,
My lord,
the brief.
written
the point,
argument, my lord.
Yes. So that will help me also. So, in the meantime, if I'm keeping it CAV.
CAV.
So in the meantime, so by Monday or Tuesday,
Monday, Tuesday.
or by next week?
I'll try. By next week,
Oh.
I'll try.
Unless I get it by
By-
next week, then it will
Yep.
be difficult, then I'll have to carry it to summary steering
My-
wheel,
my-
outlying bench. So by next week? Okay.
My lord, my learned friends trying to project that the interim status quo order that was passed without hearing me, as if that order will have any relevancy now. Not, my lord is not dealing with the IA now. My lord is dealing with the appeal altogether.
Appeal.
If appeal is allowed, then they will get the, but prayer is not there, they will get whatever.
Also, there is prayer. I think so.
It's okay.
So, you have heard, have you seen that is there any prayer in your appeal? So I need to confirm, because he has raised that there is no prayer, and also shown the Supreme Court.
My lord, can you see the page number 12?
Yes, 12. It's for,
The last.
yes.
Who did the reason stated herein above, the impugned order dated 4/10/2020 is liable to be set aside.
Okay.
This is the prayer.
Okay. So what is the relief? Relief sought for?
On the reason stated above, there are so many grounds we have stated there. How this Lola Trial Court has committed the error in passing the.
Okay. No, I'm asking for the relief. Have you prayed for the relief? Any relief?
Relief is to set aside the cause the impugned
Okay.
order. That is the condition.
Okay.
Okay.
Okay. So, Haj. He is NVP singer, na? And then you are? Okay, T. Sunil, Land Council for the appellant.
Argument concluded. There is
Also had Mr. R. Sona, Land Council for the respondent. Staff, na? Hearing concluded. Judgment reserved.
deeply obliged.
Okay. In the meantime, you are?
My lord, I will.
Should I record it in the meantime?
Written argument.
Written argument.
My lord, my lord.
Okay. In the meantime, both the Land Council for the party shall submit a written argument. Okay. Yes, I have separated. Separate, huh?
My lord, highly obliged for giving a patience hearing.
So you have. Okay. Yes.